Okay, we've dealt with Dr. Ford's note, and I've requested that that be. I've seen the note that's just come on screen saying that recording has started. So just to provide a very brief update for the matter we've just discussed, for the benefit of the recording. A note's come in from Dr. Ford, the council's witness in relation to data centres. I've just asked that that be slightly amended because it strays beyond the matters I asked it to cover. The second procedural matter I wanted to raise, and it's just to say thank you for it really, is the updated viewpoint 4's come through. I've seen the note that came in from the council and the appellant's response, and I'm happy with those, and thank you for providing those before closing submissions. Is there anything that needs to be said on those before we move on, or are both sides happy with what's been exchanged?
So yeah, we're happy with the exchange.
Okay, perfect. Thank you. One other point, as I indicated during the sessions we held in the council chamber, as the Secretary of State will be determining this case, I will need to append a list of conditions to my decision letter, regardless of the recommendation that I make. And I also indicated that I'm likely to make further editorial changes to the conditions we've discussed. It's the way I tend to work. I go away and review them, and I start tinkering with the wording. But just so that everyone has a chance to see the final versions, I intend to circulate a sort of final version for comments shortly, hopefully. Just as a heads up, and to forewarn you what they'll be in, I've reworded quite a few of those conditions. I've replaced a couple with the standard PINS ones. I'm also going to attach a few comments to that document just to highlight certain changes, although not all of them, I should say. And also to seek views on a couple of issues. It's minor factual points, and so I don't think it will necessitate anything other than a brief exchange of written comments. I would ask, however, though, that when those conditions are circulated, like I say, that should be in the next week, I'll be in a position to send them out. Both sides review them carefully, and I'll give 2 weeks to respond. Just on that, actually, thinking about it, it's half term is approaching, isn't it? Will 2 weeks, if I were to circulate those conditions, say by Friday or on Monday, would 2 weeks be sufficient given it's half term, or would more time be needed? I'll just take the views on that point, please. Thank you.
So if I may, I'll wait for some instructions from. Yeah, well, Mr. Hutchinson indicates that 2 weeks should be okay, but if you were offering a third week, just in case, we would take that. So I suppose is how we would put it.
I think in an ordinary, well, I say an ordinary, if it was a non-recovered inquiry, I would probably be slightly stricter with the timescales because the pressure on getting a decision out would be more focused, and also it's a short decision to write. Given it's a recovered appeal, it's going to take me an awful lot longer to write it anyway. For example, the last recovered appeal I did was about 5 times as long as maybe 3 times as long as a traditional decision. So 3 weeks I could probably allow because I'll be taking that time to write the recommendation letter in any event. Ms. Graham-Paul, do you have any comments on that? Would 3 weeks assist in terms of your team's response time as well?
Yes, I've asked if there's any problem with that from my team. I haven't heard anything back yet, but so I assume it's all fine.
Okay. I'll allow 3 weeks then. I think there's no harm in this case, like I say, given that the recommendation letter will be a lengthy job in any case. I think those are all the procedural matters I wanted to raise. Is there anything else before we move to closing submissions?
I suppose so. Just one very briefly, and that relates to the UU. I'm told that the one wrinkle with that has proved to be getting signature from the bank. That's not going to be quite as swiftly secured as we thought it might be. The expectation is that that will be received and we will have the document to you within 2 weeks. But there is an outside chance that it might be 3 weeks. And given that we're talking in terms of 3 weeks for conditions, I was just going to ask that you allow 3 weeks for the purpose of the UU also.
That's no problem from my perspective. It's often the signatures that take the time. I've come across that before, so that's fine. We'll have the same deadline then for the UU and the conditions.
Thank you.
Okay, with those procedural matters out of the way then, I'd like to invite the council to make a closing submission, please. Thank you.
Thank you very much, sir. So in introduction, the Tech UK document, the UK data centre sector, the most important industry you've never heard of, is actually titled, "The Data Sector Centre is an important industry, and it is also one about which very little is still known, certainly outside its own secretive walls." This inquiry has sought to explore the nature of the industry, the need for future data centre capacity in the UK, and the appropriate locations for data centres in order to understand why this council's rural green belt is under threat. We hope that this approach has been useful to inform not only the Inspector USA and the Secretary of State in making this decision, but also future planning policy making, which is very much needed in this area. The difficulty many authorities have encountered, including this council, is that they lack specialist expertise in data centres sufficient to be able to test the narrative put forward by this entirely market-driven industry, and thus are forced to accept without question what is said to them about need and apparent lack of alternative, less harmful sites by developers. That is never a sound way of taking decisions which have lasting long-term impact. This is a case where there is no dispute that these two vast buildings and associated infrastructure are inappropriate development in the Green Belt. This parcel of Green Belt makes a positive contribution to at least one of the Green Belt purposes, and the development will cause significant adverse landscape impacts which are incapable of mitigation. There is also no dispute that there is an overwhelming and urgent need to provide more data centres in the UK generally, and that the provision of 96 megawatts of capacity is a matter to be afforded significant positive weight, along with the economic benefits that come with it. There are some minor differences as to weighting with regard to other associated benefits, such as biodiversity net gain, provision of the country park, etc. But these are very much peripheral to the main issue, which is, are there very special circumstances which justify the data centre buildings in this location in the Green Belt, which clearly outweigh the substantial weight which must be afforded to the inappropriate development in the Green Belt, along with the significant adverse landscape and visual harm. The appellant seeks to justify the inappropriate development of this land by saying there is simply no alternative place this data centre can go. And therefore, if not granted permission, the UK will lose £1 billion of investment to Europe, and our economic growth and IT capabilities will be severely hampered. If true, as I said in opening, the loss of such an investment would be shameful. However, as we believe the exploration of the evidence at the inquiry has shown, it is not that straightforward. Whilst there is clearly an incredibly strong market demand from the US hyperscalers to occupy London's Green Belt for their commercial ends, that does not equate to a planning necessity for this location. As I said in opening, for decision makers to simply say to the hyperscalers, "Thank you very much for choosing the UK to host your data. We are so grateful. Please go wherever you like," is a short-sighted and unsophisticated response, and is actually in the long term damaging, not only to this country in visual, spatial and landscape terms, but potentially to future planned delivery of other elements of our growth, such as housing. Data centre locational requirements are not in dispute and are actually very straightforward, as summarised in the appellant's alternative sites assessment. A reliable source of high-level power supply, typically at 132 kV, high-quality fibre connectivity, and a site that is physically large enough and flat enough to accommodate the proposed development. Notably, whilst the appellant clearly believes that the Abbots Langley site can be made to function for a data centre development, it is actually far from ideal so far as these basic requirements are concerned. First, The site has no power supply and thus requires a new power connection from the Watford South substation, which is not even its nearest substation. No details have been provided as to how this will be achieved in practice, although Mr. Collins sought to reassure the inquiry that the power will be available by the time the development is built. No supporting evidence was provided for this fact. There is no local renewable energy source it can benefit from. Second, the site has no existing fibre connections and thus requires new fibre to be put in place, as shown in the Found Digital report and confirmed by Mr. Hutchison. And third, the site is sloping in topography and thus requires very extensive cut and fill engineering operations to create a flat platform for the large buildings. So why this site? Data centres do not need to be in rural locations or on greenfield land or next to existing settlements such as Abbots Langley, all features of this site which might make the site appropriate for other forms of development. The only special thing about this site so far as data centres is concerned is that it is within striking distance of 4 existing data centres in the well-established industrial estate in Hemel Hempstead. The existence of at least 3 data centres near each other creates an availability zone, whereby each can rely on one another for resilience. So if, for example, power to one goes down, the others can pick up the load. We are told this is essential for a public cloud data centre, the type which is proposed here, albeit the planning application does not specify the type of data centre. This sets the proposal apart, we are told, from other data centre developments which can be standalone, such as the largest data centre in Europe in Cardiff and the recently permitted AI data centre in Immingham in Humber. The need to locate this data centre in an AZ or AZ is accepted. However, there is no industry or other verifiable document to support the appellant's position that hyperscale public cloud data centres can only locate in existing AZs, as opposed to leading the creation of a new AZ campus. Indeed, the Department for International Trade document, Data Center Sector Proposition, states that large US cloud companies such as Amazon, Google, IBM and Microsoft tend to acquire large parcels to develop large data center campuses and favour locations with low cost, renewable power and plenty of suitable development space. These exact same comments also find form in the Tech UK document I've already referred to. This suggests there is nothing to stop these companies forming new AZs by way of campuses, and if they do so, it is reasonable to assume that the places which are low cost with renewable power and plenty of space are unlikely to be in London. It is submitted that the appellant's locational focus on an existing AZ is therefore unduly restrictive, and indeed it appears that new AZs are being formed at Dick Power Station, at Cheshant and potentially at South Mimms. In terms of existing AZs, there are a number established in the London region as set out in Mr. Collins's proof, in addition to Hemel Hempstead, Slough, Hayes, North Acton and London Docklands. The large number in London is a result of history, or as the Tech UK document states, age, beauty and experience. By being first, London attracted key players and around them a complex ecosystem has developed. Beauty is the attractiveness of London for investors and for skilled staff seeking a career in the sector. Experience is London's world-class expertise in investment, finance, design, engineering, construction, technical brokerage, etc. However, aside from history and population size, there is nothing special about London in being more suitable for data centres than anywhere else in the UK. The appellant's position was staunchly London-centric, to the extent that Mr. Nicholl said that despite there being already around 40 data centres in Manchester, Manchester cannot be classified as an availability zone and is, and I quote, not attractive to large hyperscale data centres wishing to locate in the UK. Mr. Collins stated that Manchester is an emerging availability zone, but is still too commercially risky to attract big US hyperscalers. The appellant's somewhat depressing position is that, at least for the foreseeable future, all hyperscale public cloud data centres can only be located in the London region, notwithstanding the relative economic advantages for the UK of locating them in areas that are more needing of foreign investment, economic advantages that were fully acknowledged by Mr. Nicol. The Council acknowledges that it may be more convenient for US hyperscalers to focus only on London in the context of global expansion. However, a non-London location could have wider benefits, not only for the UK's economy, but also in terms of improving connectivity for other major urban centres, such as in Scotland and the north of England. These are really wider policy points for the government to consider in the future, and the Council acknowledges that there is, in any event, some need in the London region. However, in the context of this decision, it should not be assumed that if permission is refused for a data centre in the London region, that the UK will be completely abandoned by the US tech giants. It may simply be that, in what is an entirely market-driven industry, if government steps in and regulates its land use, the market will adapt. As well as stating that this type of data centre can only be located in the London region, the appellant goes further and states that it can only be located in the Hemel Hempstead AZ. Their position as to why this is so has shifted. In the Found Digital report, which accompanied the planning application and formed the basis of the alternative sites assessment, it was stated that there must be equivalence of scaling between Slough and Stockley Park and Hemel Hempstead. In other words, servicing growth within Slough or Stockley Park and not being in a position to service equivalent growth or scale in Hemel impacts the entire region because it results in loss of fault tolerance of the overall system. It was further stated that the demand within the Hemel AZ is likely to be at a very different inflection point to Slough and Stockley Park. Mr. Collins also referred to the concept of load balancing to suggest that every AZ must grow at the same rate. This is not, however, what has happened on the ground historically, as Dr. Ford noted. Indeed, the Found Digital report itself observes that, and I quote, the bulk of the London area's data centre investment over the course of the last 36 months has focused on developments coinciding with a westerly lateral from Park Royal Power Gate in the eastern extreme, incorporating Hayes and Stockley Park and then extending out towards Slough in the west. Whilst it may be that on paper every AZ will be in an ideal world the same size, that is not and can never be what happens in reality, because there are market forces at play, availability of land, power, etc., and indeed planning constraints. In the end, Mr. Collins stated in oral evidence, perhaps mindful of the fact that significant data centre development is also proposed in the Slough AZ, which may outbalance Hemel, that it actually was a case that there was simply so much demand that every AZ must grow as much as possible. There is thus in the Council submission no technical reason why this data centre needs to be located in Hemel as opposed to in Slough or any other London AZ. Turning to the market, there was a statement in the Found Digital report that this data centre must be located in Hemel because it is a very specific child data centre to an unspecified hyperscaler A who is already located in Hemel. Particular facts about hyperscaler A were relied on to justify the location of this child, such as that hyperscaler A specifies that the optical route lengths must be no greater than 11 kilometres. This raises the question, who is hyperscaler A and why this specific parent-child relationship? Mr. Collins stated that there was no official agreement between any existing data centre in Hemel for a parent-child relationship, but any existing data centre would inevitably be prepared to be the parent, as it would be such a good thing. He stated that hyperscaler A could be any of the NTT data centres already in Hemel or the AWS data centre. Given that the specific identity of the parent operator appears to be at large, that calls into question any suggestion that Hemel is a necessity due to a particular relationship with an existing data centre there. In the Woodlands Park appeal decision, the inspector noted in his reasoning that the council had agreed that it had not identified any alternative sites for a hyperscale data centre. However, no analysis of sites that might be located in other availability zones in London had been undertaken. The then Secretary of State took into account that there are other AZs within London which are not within the Green Belt, and that no analysis of sites that might be located in other AZs in London have been undertaken. It was on that basis that he gave no more than moderate weight to the absence of an identified and readily available alternative site for a hyperscale data centre in the Slough AZ. Mindful of that decision, where Greystoke was also the developer, and the need for decision makers to act consistently, it is incredible that no one in the appellant's team advised carrying out a London region-wide alternative sites assessment, or alternatively sought to explain anywhere until after the point was raised with Mr. Collins in cross-examination why the Secretary of State was wrong to expect a London-wide search. In oral evidence, Mr. Hutchison stated the Secretary of State simply did not understand the way data centres work. With respect, the Inspector and Secretary of State were not wrong, for the reasons I've already set out, and there are no good reasons for not adopting a consistent approach. This is not a case of just passing the buck around the London AZs. It is simply that, in order genuinely to rely on an absence of alternative sites, the appellant needs to look to at least the London region for a hyperscale cloud data centre, and not just to the particular AZ within that region where it happens to be promoting a site. As I've set out, there is no technical reason why a data centre of this kind cannot be located in any of the London AZs. There are many areas of London which are not in the Green Belt, and indeed include significant portions of brownfield land begging for regeneration. A refusal to consider prioritising such sites is a serious failing. Even adopting a Hemel-centric constrained approach, the appellant's alternative sites assessment is seriously flawed. The most obvious failing is the imposition of a hardline 8-kilometre search radius around the existing data centres in the Hemel industrial estate. This 8-kilometre radius arises from the Found Digital report. The report states that for parent-child data centre relationships, a below 11-kilometre to 19-kilometre optical fibre route length on both primary and diverse paths is required, but that in this instance, hyperscaler A specifies that the optical route lengths must be no greater than 11 kilometres. Mr. Collins sought to suggest in oral evidence that the quoted 11-kilometre to 19-kilometre figures should mean there and back, so the actual fibre length is 5.5 kilometres to 9.5 kilometres, although he said that the 11-kilometre figure given by Found Digital is one way. That simply cannot be right. Not only does it go against the natural reading of Found Digital's text, but also adjusting for typical fibre routing being 1.3 to 1.8 times the direct line of sight, as the crow flies, it actually puts this data centre too far out of the Hemel parents in terms of typical routing lengths, according to Mr. Collins. In any event, it is inconsistent with the figures given by Mr. Nicol. Mr. Nicol states that optical fibre distance between sites is typically no more than 10 to 20 kilometres, with no suggestion that this is there and back. It is also inconsistent with the practical reality of new data centres coming forward in this area. Mr. Collins stated in his proof that the Riverside Industrial Estate London Colney permission, which includes the data centre, is within the Hemel AZ. Yet, it is agreed that this data centre proposal is outside the search area adopted by the appellants. In oral evidence, Mr. Hutchison sought to suggest that the London Colney permission is an anomaly or might even not work as a data centre. There is no evidence of this, and it is simply not a credible position to take. The reality of what has happened here is that typical fibre routing lengths have been ignored in order to impose a hard limit of 11 kilometres, apparently at the behest of hyperscaler A, scaled down to 8 kilometres to take into account routing. The problem with this, however, is that, as I've already set out, hyperscaler A is not a specified parent, and as we know, could be either NTT or AWS or any other data centre which comes forward in Hemel. And so there is no evidence to support an artificially constrained radius on account of the parent's individual requirements. The appellant relies on the fact that at Woodlands Park, the search area was a 7.5 kilometre radius, but the accuracy of this was simply not tested at that inquiry. It is thus not a sound precedent. Ultimately, as the appellant says, the maximum distance between parent and child is dictated by ensuring that a less than 2 millisecond ping time is achieved from the parent data centre. However, it has provided no evidence whatsoever that that cannot be achieved using the typical optical fibre lengths in this case. Adopting typical optical lengths would give a much larger radius and potential scope for site search within the Hemel AZ. Just looking at a map, one can see urban areas within that wider scope. It cannot be assumed that no other sites outside the green belt would have been located if a proper methodology using the appellant's own stated typical fibre lengths had been used. Further artificial restrictions have been placed on the site search. The appellant looked only for sites which were 5 hectares or more. This assumes that the data centre can only come forward in exactly the same form as that proposed. Whilst an alternative site must be suitable for the development as proposed, there is still a requirement for flexibility and realism. As Dr. Ford has pointed out, the appellant could have looked at smaller brownfield sites, bearing in mind the data centre could be multi-storey, or looked at more than one site by disaggregating the buildings. That would have opened up the possibility of alternative sites outside the green belt being available. For these reasons, even if the Secretary of State was wrong to criticise Greystoke for not conducting a London region-wide alternative site search in the Woodlands Park decision, the artificially constrained nature of the Hemel search undertaken should still lead to the same conclusion that no more than moderate weight can be afforded to the apparent absence of alternatives in this case. Although the level of need for data centres is not disputed, it is worth putting this in some context. First, there is no independent objective assessment of exactly what the need is. The appellant itself has produced conflicting need figures. The alternative site assessment submitted with the planning application stated that the need in the Hemel AZ is 500 megawatts, equating to a need to find more than 5 sites of the equivalent size of the application scheme. However, Mr. Collins states that the need is actually more likely to be 352 megawatts by 2029, based on his own calculations provided when he was employed by JLL, which were accepted in the context of the Slough AZ in the Woodlands Park appeal. There was no testing of these figures at Woodlands Park, and this inquiry has not been provided with the raw data. Mr. Collins himself acknowledges that there is a degree of uncertainty in such estimates. As Dr. Ford stated, they appear to overestimate the level of historic growth in London. Therefore, the exact level of need is difficult to be precise about. Second, it is impossible to predict the need beyond 2029. This is not just because property predictions struggle over a longer period. It is also because, as the Tech UK report says, looking ahead in an industry characterised by disruptive technology is tricky. What we can say confidently is that it will change. Change does not necessarily mean that the demand will continue to go up and up indefinitely. There are a number of things that could happen. Human behaviour may change if a ceiling in demand for public cloud data storage may be reached. Technology may advance so that such large buildings are no longer needed for data centres. Solutions may evolve to enable public cloud data storage in more environmentally suitable locations, as is happening with AI data centres. The future is unknown, and so no reliance can be placed on any long-term need. This is particularly important in a greenbelt case, where the consequences of building on this land will be permanent and irreversible. Third, the need is for data centres generally, and not just for this specific type of hyperscale cloud data centre, and thus can and will be met elsewhere and in other forms. This particular development can only meet a certain portion of the general overall need. For these reasons, significant weight should be afforded to the provision of 96 megawatts of capacity to meet the need for data centres, but no more than significant. Moderate weight should be afforded to the apparent absence of alternative locations to meet the need, given the flaws in the alternative sites assessment and the failure to look across the London region. The appellant's suggestion that an apparent policy failure should weigh in favour of granting permission for data centre applications generally should be given no more than limited weight. Whilst the Council strongly encourages further guidance from the Government on the need for data centres and where they should go, this is not a situation where a council should be punished for not having site-specific allocations in its local plan for data centres. Very few, if any, councils do, as Mr. Carpenter explained, quite simply because so little is known about the entirely market-driven requirements. Until such time as there is either a national strategy for or national guidance on data centre development, each application must therefore be determined on its own merits, but bearing in mind the wider picture set out above surrounding need and alternative sites to meet the need. Against that background, I turn to consider, are these matters sufficient to clearly outweigh the greenbelt harm and other landscape harm in this case? The NPPF provides that the government attaches great importance to green belts, and this is not set to change in the emerging revisions. The green belt is necessary in a constrained island such as Britain and has been an integral part of our planning system since the seminal post-war Town and Country Planning Act of 1947. Its essential characteristics are its openness and its permanence. Both will be severely compromised in respect of Parcel 1 by the vast data centre buildings, and that is by definition harmful. Policy dictates that substantial weight must be afforded to that harm. It is not just definitional harm that will be caused. This site forms part of Parcel N12, which was objectively assessed by Amec Foster Wheeler as part of the Council's Stage 1 Green Belt study in terms of its contribution to the 5 Green Belt purposes. It was found to make a significant contribution to the purpose of checking the unrestricted sprawl of large built-up areas, a significant contribution to assisting in safeguarding the countryside from encroachment, and an overall significant contribution to green belt purposes. The appellant seeks to depart from these findings by arguing that Abbots Langley, despite being a settlement with a population of some 22,000, is not a large built-up area, and that in any event, the development is not unrestricted sprawl because it will be bounded by the M25. They also argue that the Greenbelt assessment looked at a wider area of land and so is somehow to be applied differently in respect of the appeal site. On the first point, there is no definition of large built-up area in national policy, and this is a matter of judgment. Abbots Langley, whilst historically a village, is by any accounts large and built up. On the second point, the positioning in relation to the motorway bears a striking resemblance to that in Woodlands Park. As was the case there, the development will extend outwards from a defined settlement boundary. Greystoke also ran the argument at Woodlands Park that the M25 would limit any further expansion. However, as the inspector stated, the motorway is a relatively new piece of infrastructure and should not be regarded as the new urban edge. As Ms Tinkler explained, the presence of the motorway is not a dominating urban influence. The same points apply here. In respect of safeguarding the countryside, there is no reason why this parcel, which marks the start of the green belt on the urban fringe of Abbots Langley, does not perform any less strongly than other areas assessed, such as those specifically mentioned to the northeast of Watford in the green belt study. The extensive urbanising features of buildings, vehicular access, parking areas, perimeter fencing and lighting will clearly represent encroachment into open countryside, which is of good quality with many positive aesthetic and perceptual qualities. This is active agricultural land, not poor grade previously developed land. Mr Hutchison accepts that this area performs moderately against Purpose C and the development will cause moderate harm. Thus, even on the appellant's own assessment, there will be harm, and there is not a huge degree of difference between Mr Hutchison's moderate harm and Mr Carpenter's significant harm. Mr Carpenter's assessment is, however, entirely consistent with the independent objective study commissioned by the Council, and so should be preferred to Mr Hutchison's assessment, which has no peer review or other external support. In terms of the visual and spatial elements of openness, it is obvious that these characteristics will be severely harmed given the size and bulk of these vast utilitarian buildings with a combined floor space of some 84,000 square metres. In addition, the development includes other large buildings, substation and education building, as well as new secure vehicular access with a gatehouse and significant new internal roads around the buildings. The scheme will also require significant retaining structures to create the platforms required for the large new buildings on this sloping site. This will limit the available area for any meaningful new planting, as I will come on to explain, and the significant adverse effects on character and appearance are agreed. The fact that there was at one stage a proposal to release this land for housing in the emerging local plan process makes no difference to the contribution made to greenbelt purposes or the impacts of this development. Housing and affordable housing are acutely needed, and in an area such as Three Rivers, which is heavily constrained by greenbelt, much will inevitably have to be delivered on greenbelt land, even if it is of high quality and contributes strongly to one or more purposes. That was the case here, and the housing allocation, which was withdrawn by the promoter, was noted to give rise to moderate to high harm if released. Housing in this location would be sustainably located on the edge of a growth settlement. Granting permission for a data centre would have the effect of meeting a data centre need at the expense of meeting a housing need on this site. If it is relevant at all, the backdrop of a potential release of the land for housing should, contrary to the appellant's arguments of support, actually be a matter which weighs against granting permission for the data centre. By way of an aside, both parties made submissions on whether the current proposed draft definition of grey belt in the emerging MPPF and associated proposed annex definition would be met. The Council's position is that it would not, because this parcel makes a significant contribution to at least one greenbelt purpose. However, there is no point in making any finding about this at this stage, since the definition is subject to consultation and may well change, and to do so would be premature. If a new MPPF is adopted before the decision in this appeal is reached, then further submissions can be made. Furthermore, when the definition is settled, it is highly likely that the council will commission evidence to identify its own pieces of grey belt land so that a standard approach can be adopted across plan making and decision taking, and this decision should not preempt that process. I turn then to the agreed other harm to character and appearance, that's landscape and visual amenity. There is no dispute that the data centre would give rise to direct, significant, very substantial adverse effects on the character of Parcel 1, which could not be mitigated and would endure for the lifetime of the operation. At Year 1, it is also agreed that certain visual receptors would experience significant, very substantial and moderate to substantial adverse visual effects from the development. These include the residents and users of Bedman Road and the motorway bridge, residents of Knockley Court, users of East Lane and users of other public rights of way, in particular the popular Hertfordshire Way. The data centre site is an agricultural field. It is not valued landscape in the context of the NPPF, but is a good example of its type and has many positive aesthetic qualities and performs several valuable functions, for example, as an urban-rural buffer or transition zone. It is historically a traditional agricultural landscape, and this form of modern industrial development is entirely at odds with it. The presence of the M25 is a landscape detractor, but it is not a dominant urbanising influence. Motorways are infrastructure corridors and features of many countryside locations, and this section, as Ms Tinkler explained, runs through a very wide and long open swathe of countryside, where large-scale built form is entirely absent. It is well wooded and partly in cutting. The presence of and noise from the motorway is not disturbing. Indeed, parts of the site are surprisingly tranquil. Proposed within this landscape are two very large box-like utilitarian buildings around 20 metres high, with protruding chimneys of a further 5 metres in height, along with a substation and associated access roads, parking, lighting, staff, traffic, etc., all surrounded by high security fencing. The buildings dominate Parcel 1 to the extent there is no opportunity to make this a landscape-led scheme, and all SUDS mitigation and a vast amount of the BNG has necessarily to be provided on Parcel 2. Notably, due to the sloping nature of the site, the buildings would have to be cut into the landscape. This is a necessity to create a flat site and has nothing to do with landscape mitigation. On the contrary, while the cut may reduce the height of the buildings from some areas, they are artificially built up in others, so that users of East Lane, for example, will be confronted with an almost vertical wall along that path, and the maximum height will be 20 metres plus around 12 to 14 metres AOD. The proposals to retain and enhance existing boundary hedging where possible, plant trees throughout the development and clad parts of the building with living green walls can only do so much. It is agreed that visual effects arising from the introduction of new large-scale buildings cannot and should not be fully mitigated by screen planting. The proposed screening is an attempt at mitigation, and it should not be viewed in any way as an enhancement to the existing situation. There is a dispute between Ms Tinkler and Mr Harris as to the Year 15 effects on views. Even if the development could be completely screened, the residual level of visual effects would remain very substantial adverse due to the total loss of the view from the Ovaltine Farm cottages, Bedman Road and other locations. In any event, the prospect of total screening now appears to be impossible, certainly from the Hertfordshire Way, as shown in viewpoint 4. The appellant's corrected image shows very little change from this location in Year 15 from Year 1, with the data centre building remaining strikingly visible in the existing hedgerow gap, and thus there must be, as a minimum, significant adverse effects remaining in Year 15 from that position. Moving further to the east, viewpoint 3 indicates that the scale of the development rises above the existing woodland areas at Year 1, and this will not change at Year 15. This is a longer distance view and indicates that the long-term significant adverse landscape impacts will extend well beyond the immediate experience of the site. Due to the lack of remaining space on Parcel 1, it has been necessary to construct the SUDs on neighbouring sloping land on Parcel 2 with an apparent pipe running under East Lane with unknown effects, as well as wetland ponds to contribute to BNG. These will be water features constructed on slopes. To retain water on a slope will require some sort of artificial engineering. The details are unknown at present and will be for reserve matters. However, as Ms. Tinkler explained, there is at least a risk that these themselves will cause potentially significant adverse visual and landscape effects in and of themselves. Whilst this was clearly not the Council's primary concern in refusing permission on landscape grounds, it is an additional matter which adds to the difficulties arising from seeking to fit this vast development onto a constrained sloping site. If the proposed country park, which is at present also a pleasant agricultural field which contains a number of public rights of way where people go to enjoy the countryside, contains suburban style park features such as litter bins, benches, paths, etc., that will also be adverse. Mr. Harris sought to suggest this is not what was proposed, and the country park would be grassland and mown paths, a matter to be taken forward at reserve matters. Be that as it may, Parcel 2 simply does not need changing and is perfectly fine in landscape terms as it is. The only reason it is being tampered with by the appellant is to make up for the shortfalls in Parcel 1 in failing to be able to provide the necessary SUDs and BNG. It is noteworthy that the idea of the country park appears to have been an idea alighted upon by the appellant's team with zero input from the community or those responsible for the neighbouring Leavesden Country Park, to which it is described as an extension. It is neither needed nor wanted. Leavesden has excellent facilities, and Parcel 2 itself is already accessible to the public through a multitude of public rights of way. As Ms. Tinkler explained, who actually, unlike the appellant, has spoken to users of the prows in and around Parcel 2, people value the fact that Parcel 2 is rural and is not a park. The idea that giving people access to walk all over the field as opposed to on the existing public rights of way is somehow a major benefit of the scheme is nonsense. Although it sounds like a good thing on paper, which is no doubt why the council officers supported the idea, when looked at in more detail, no more than limited weight should be afforded to the provision of the country park, and there are no landscape benefits associated with it. All in all, it is agreed between the parties that the landscape harm is very substantial adverse. It will remain so in year 15 and beyond. This is the highest level of harm in LVIA terms and arises from poor site selection. Whilst Mr. Harris's opinion is that significant adverse visual effects could be adequately mitigated by year 15, Ms. Tinkler's position is to be preferred. In most cases, visual effects would remain significant adverse at year 15 and beyond due to factors such as screening, resulting in the total loss of a view, or in other cases, the proposed buildings remaining visible above existing more mature trees, for example, viewpoint 3, or proposed buildings remaining visible due to the inability to provide meaningful screening, for example, in the corrected viewpoint 4. Mr. Carpenter has properly considered all the benefits of the scheme cumulatively in judging whether they clearly outweigh the substantial green belt harm and very significant landscape harm. Whilst the benefits are considered cumulatively, the reality is that the only ones which go to the principle of the development itself in the green belt in this location, as opposed to the design and individual characteristics, are the need for data centres in the Hemel AZ up to 2029, the ability of this scheme to contribute towards that need, the financial economic benefits that will arise from this scheme, and the apparent lack of alternative non-greenbelt sites within the Hemel AZ. The other very special circumstances are really add-ons, i.e. they would not justify the development alone, And in the council submission, the scheme succeeds or fails based on whether the apparent requirement to meet the data centre need on this site clearly outweighs the green belt and landscape harm. Significant weight is afforded to the need, the economic benefits and employment benefits. However, due to the serious shortcomings with the alternative sites assessment, as I've set out, only moderate weight should be afforded to the apparent lack of alternatives, a position which is consistent with the Woodlands Park decision, albeit for additional reasons. This is insufficient to clearly outweigh the significant harm to the openness of the green belt, the significant harm to the purposes of the green belt, and the significant harm to the landscape character. The appellant has thus failed to discharge the burden of showing that the very special circumstances test is met in this case. As I said in opening, to permit this scheme on account of the very special circumstances put forward here, on a site which is not particularly ideal in terms of data centre requirements, is not low quality previously developed greenbelt land, and which will result in very significant landscape impacts and will take out a potential site to deliver much needed housing, would effectively give licence for any new data centres to be built in the greenbelt, irrespective of the impacts, so long as there were no technical impediments. Establishing very special circumstances should not be such an easy task. This council, like any reasonable authority, wants to respond to the demand for new technology and to see investment of this scale in the UK after more than a decade of slow economic growth, chronically weak productivity and struggling public services. But caution is necessary. This is simply not a good site. The US hyperscaler demand is massive, but USA and the Secretary of State must still be able to have influence and exercise control over the use of our land. And accordingly, USA and the Secretary of State are urged to act in accordance with long-established Greenbelt policy and general principles of sound planning in this appeal and refuse planning permission. Thank you very much, sir. Those are my closing submissions.
Thank you, Ms. Graham-Paul. I think before we go on to Mr. Beard's closing submissions on behalf of the appellant, we'll take a short mid-morning break. Can I just ask as well, Mr. Beard, has your closing submissions been sent through as a document to Alison Dyson yet? I only ask because I haven't got it in my inbox yet.
So, as I understand it, that document is being sent through to you this very moment. So you're being sent it now. I think it's also being sent to the council. My learned friend and I, though we are in different rooms, we are in the same building. And in a moment, I'm going to walk downstairs and give her a hard copy of my document. So, sir, you will, I mean, if we were to have a short adjournment, say till 11:10 or similar, then she will have the document, and so the document should also be in your in tray also.
Perfect. Okay, 10 past was the time I was thinking of, so we'll take a short mid-morning break then and return at 11:10 for the appellant's closing submissions.
Thank you, sir.
Okay, thank you. The inquiry is resumed. I can confirm, Mr. Booth, I've received a copy of your closings in the breaks. Thank you very much for those. In which case, I invite you to make your closing submissions on behalf of the appellant. Thank you. Sorry, Mr. Booth, you're on mute.
That would not have been a very effective closing submission, so thank you very much for that. I begin by saying that, as was noted in opening, this inquiry concerns an appeal made by Greystoke Land under Section 78 of the 1990 Planning Act in relation to the refusal by Three Rivers District Council to grant planning permission in respect of the appellant's planning application concerning proposed development on land north of Abbots Langley. The planning application sought outline planning permission for development in the following terms, and so I've there set out the description of development. As we come to the close of these proceedings, we can note that the inquiry has heard evidence from the parties on economic benefits, data centre need and locational requirements, landscape and visual issues, and planning matters, including green belt. That evidence now having been given, the appellant maintains in closing submissions that its case has been shown to be robust and has withstood all scrutiny. Conversely, the appellant respectfully contends that the reasoning and analysis relied upon by the council has been shown to be flawed. Indeed, in certain respects, it has been shown to be positively unsound. In the course of these closing submissions, the appellant will address those matters which fall to be considered in the context of what all parties agree is the sole test or balance to be applied in the context of the appeal. That is, the test relating to very special circumstances as set out in national policy, which is engaged in light of the fact that the scheme, as the appellant has always acknowledged, comprises inappropriate development in the green belt for the purposes of national policy as it currently stands. However, before turning to those matters, the appellant needs to address a number of preliminary issues, most notably the position adopted by the council's witnesses in seeking to substantiate the council's decision to refuse planning permission in respect of the scheme. However, before turning to that matter, the appellant's submissions first deal briefly with some less controversial points. Firstly, reason for refusal 3. So the council determined to refuse the planning application on the basis of 3 reasons for refusal, and of these, the third is concerned with sustainable travel contributions. Both parties acknowledge that the reason for refusal is capable of being addressed by way of a planning obligation completed pursuant to Section 106 of the 1990 Act, and a draft of such an obligation has been provided to you, sir. Accordingly, these submissions do not address reason for refusal 3 further, and so we've confirmed that you will have the final document within 3 weeks. Next, the obligation, education and local employment commitments. So the appellant has determined to include within the obligation clauses which provide for the creation of an education fund of some £12 million, and which provide also for certain priorities to be given to local people in terms of the employment opportunities which the scheme would provide. So the appellant is content to make such commitments and notes that similar ones were made in the context of its proposals regarding data centre development on the Woodlands landfill site in the Slough availability zone. However, as discussed during a roundtable session concerning the obligation, the appellant is adamant that any permission which is ultimately granted by the Secretary of State should be as robust as possible. Accordingly, sir, and recognising a degree of doubt and concern as to whether these provisions would satisfy the test of necessity set out in Reg 122 of the SIL regulations, so we ask that neither matter be taken into account by you, sir, or the Secretary of State in the making of your recommendation and the Secretary of State's decision. So accordingly, the only commitments in the obligation to which we suggest regard should be had in the determination of the appeal are those regarding sustainable transport. Again, to be clear, this does not mean that the appellant will not be bound by the requirements to provide the education fund or support local employment. It is only that it asks that such matters be excluded from the planning balance. What may be included in the planning balance, sir, should you or the Secretary of State deem appropriate, is the weight that could be attached to the benefit comprised in a skills education scheme secured by way of planning condition. And so you'll recall that was the evidence given by Mr. Hutchison during the roundtable session, And I note in the footnote there, sir, foot of the page, that such an initiative attracted moderate weight from the Secretary of State in the context of the Woodlands landfill site appeal. So I turn now to the final preliminary matter, and that is the appellant notes that the council's witness team at this appeal is not comprised of council officers, nor anybody that had involvement prior to the determination of the application. Rather, it is comprised of external consultants. Now, so that is, of course, in and of itself wholly unremarkable. Local planning authorities frequently resource their appeal function with external assistance. However, what is of more concern is that it is apparent from the proofs of evidence submitted by those consultant witnesses that they did not regard their role as being to substantiate the decision of the democratically elected council members who had determined to refuse the planning application. Indeed, sir, both Dr. Ford and Miss Tinkler confirmed in answers to direct questions in cross-examination that they did not regard themselves as constrained by the basis on which the council had determined to refuse permission. Rather, they said that they felt entitled to conduct a full review of the planning application and give their evidence accordingly. Mr. Carpenter's position was similar, but slightly more nuanced. His view was that so long as he could bring arguments within the bounds of the council's 3 reasons for refusal, he was entitled to run those arguments. He certainly did not regard himself as in any way bound by the views expressed by officers in the officer report, which informed the decision of members. So I referenced the statement of case in the footnote, but you can read that for yourself. So such position on the part of the council's witness team is quite simply wrong. The current appeal proceedings are concerned with the appeal by the appellant against the decision of council members, properly informed as it was by a lengthy and thorough officer report. The role of the appellant is to address the decision of the council and the analysis said to support it. It is not to grapple with whatever new and imaginative arguments the consultant witness team, now retained by the council, may seek to deploy in order to try and resist the appeal. So in this regard, the legal status of the council's position is clear, as recently confirmed in the Zurich Assurance case. So the point I make here, sir, is that I notified my learned friend of my intention to rely on this decision yesterday, and indeed all the other decisions I refer to in these closings. So, in that decision, Mr. Justice Higginbottom noted the basis on which a local planning authority is deemed to have determined a planning application in circumstances where it has adopted the recommendation in a report prepared by officers. So Mr. Hutchison referred to this decision in his evidence. I think he was being cross-examined by the friend, or else he was chiefed by me at this point. And the key passage, sir, is this. Mr. Justice Higginbottom stated, each local planning authority delegates its planning functions to a planning committee, which acts on the basis of information provided by case officers in the form of a report. Such a report usually also includes a recommendation as to how the application should be dealt with. With regard to such reports, in the absence of contrary evidence, it is a reasonable inference that members of the planning committee follow the reasoning of the report, particularly where a recommendation is adopted. So in the present case, it is clear and not disputed that the council's planning committee adopted the recommendation of officers and indeed, sir, the recommended reasons for refusal as set out in section 8 of the officer report. Thus, members refused the planning application for the reasons for refusal set out and on the basis of the analysis contained in the officer report. There is certainly no evidence to the contrary. Now, sir, of course, it would have been open to the consultant team to ask that the members' resolution be taken back to committee prior to the consultant's evidence being given at the inquiry in order to introduce new reasons for refusal which would justify that evidence. However, sir, this was not done and there is no fresh resolution before the inquiry. Indeed, the council's witnesses were asked this point expressly in cross-examination and confirmed that no fresh resolution existed. So to be clear, this is not to say that a consultant team representing a local planning authority at appeal is tied to the very letter of every judgment in an officer report. There must be some practical degree of latitude allowed for differences of judgment as to the weight to be attributed to particular considerations. And so you'll recall Mr. Hutchison confirmed this in his evidence in chief. However, that is a very different matter from consultants regarding themselves as being entitled to introduce new matters and fresh lines of argument, disputing points that were not disputed by officers and members. Thus, in the present case, for example, sir, it was not open to the consultant team to do the following: contest the substance of the appellant's case regarding alternative sites, as set out in the ASA, where that ASA had previously been accepted by the council in terms of members and officers. Next, dispute the need for the scheme within the Hemel Hempstead availability zone, where that need had previously been accepted by the council in terms of members and officers. Lastly, raise concerns regarding matters such as ecology, fire risk, noise and groundwater contamination, where the council, i.e. members and officers, were satisfied in respect of those issues. Most importantly, perhaps, sir, it was not open to the consultant team to allege harm in landscape terms by the provision of the proposed country park on Parcel 2, where the council, i.e. its members and officers, had found no such harm to exist. So it is this last issue that is perhaps the most egregious example in the present case. Neither officers nor members saw any disbenefit whatsoever in the country park. On the contrary, its provision was welcomed by officers, both at pre-application and at determination stage, with officers noting that it provided the opportunity to secure beneficial landscape impacts. So that is important, and I give you by way of example what my learned friend says at the end of paragraph 46 of her closings. The final sentence of that paragraph reads, although it sounds like the country park is a good thing on paper, which is no doubt why the council officers supported the idea, when looked at in more detail, no more than limited weight should be afforded to provision of it, and there are no landscape benefits associated with it. Thus, my learned friend says no landscape benefits associated with the country park. In my closing submissions, I've taken you to the precise reference in the officer report adopted by members, which says that there are beneficial landscape impacts, moderate beneficial landscape impacts. Returning to my text, halfway down paragraph 17, line beginning beneficial landscape impacts, I'd go on as follows. None of the reasons for refusal cited any harm in respect of the country park, a fact acknowledged fairly by Miss Tinkler, who accepted that she had read reason for refusal to incorrectly, and that in fact it was not concerned with the country park at all. So conversely, Mr. Carpenter sought to maintain that reason for refusal to did relate to the country park, even in the face of the numerous references in the officer report which demonstrate otherwise. So such assertion does his professional credibility no credit. It is manifestly wrong and wholly unsupported by the evidence. To be clear, the planning world is not the world of Humpty Dumpty, where words can mean whatever someone might wish them to mean. The fact of the matter is that members were in no way concerned about adverse impacts from the country park, and to the extent that Mr. Carpenter and Miss Tinkler have sought to argue that the scheme should be refused planning permission on that basis, they have departed entirely from the position of their client. So they have simply no authorization to contest these points. The further point I note briefly here, sir, is this. My learned friend made not a single reference to this issue in her closings. That is to say, there was no acknowledgement at all of the extent to which her submissions or the evidence of the witnesses that she called departed from the position of the council. So I say nothing more than that is extremely surprising. The best supposition I have is that in seeking to ignore the point, my learned friend hopes that you will forget about it. So it is not a matter which can be forgotten about. And it bears directly on the weight attributable to the evidence of her witnesses, as I'll come to in a moment. Returning to the text at paragraph 19. So this position, that is to say, the approach of the council's witnesses, is of particular concern in circumstances where that team each also accepted in cross-examination that in the course of producing their written evidence, they had seen fit to omit references to various documentation which told against the line of argument that they were seeking to pursue. Documentation which they nevertheless conceded was relevant and of which they claimed to be aware. So this is wrong. A witness cannot simply cherry pick in this way. A partisan, partial approach to the giving of evidence is wholly inappropriate, and such approach must undermine the calibre of that evidence and the weight attaching to it. Notably, sir, Mr. Hutchison referenced all manner of what were to him unhelpful references in his proof, and sought to express an impartial opinion which had regard not only to supposedly positive considerations, but also negative ones. So the question then arises as to how you and the Secretary of State should proceed. So you will note that having raised its concerns during the course of the inquiry, the appellant has not sought to prevent the council's consultant team giving evidence as they see fit. In this respect, we did seek to avoid being obstructive and have sought to facilitate the running of the inquiry. However, when it now comes to the determination of the appeal, it is important that you, sir, and the Secretary of State recognise that insofar as the consultant team representing the council raise issues without authorisation, whether regarding the ASA, regarding the need for the scheme in the HHAZ, regarding matters such as ecology, noise, contamination, fire risk, or regarding alleged harm to be caused by the country park. So those witnesses raise those issues on their own. Neither the appellant, nor council members, nor council officers support those concerns. The fact that the consultant team are running their own case and not that of the council should go directly to the weight to be attributed to the concerns which the consultant team are raising. So in this regard, insofar as the council's witness team raise matters which go beyond the case determined by members on the basis of officers' recommendation, those matters should attract very limited, if any, weight in the planning balance. So I turn now to the scheme and the determination of the appeal. So as noted at the outset of the inquiry, the scheme as proposed on the appeal site will deliver essentially two core elements, one being the proposed data centre and the other being the proposed country park, together with ancillary development. So the council determined to refuse the planning application in a decision notice dated January 24. The decision was taken by members on the basis of the analysis set out in the officer report, with two operative reasons for refusal. And so I've set those out. I don't propose to read them. As noted above, sir, the parties agree that the appeal falls to be determined by means of the VSC test. And given the apparent uncertainty on the part of Mr. Carpenter as to the nature of this test, that's something I'll come to in a moment, we do, sir, summarise the correct approach by reference to relevant case law as follows. First, sir, in circumstances where, as here, an application is seeking planning permission for inappropriate development in the Greenbelt, the only test which falls to be carried out is the VSC test. Further, sir, that test embraces all relevant planning considerations. And so I give you there the reference to Mr. Justice Holgate in Monk Hill, with which I know you are familiar. Second, sir, the VSC test entails the weighing of all harms that would result from development, both Greenbelt harm, to which substantial weight should attach, and other harm. It is only where such harms are clearly outweighed by other considerations, critically, sir, not benefits necessarily, but other considerations, and that's the point which Mr. Carpenter had not grasped. It's only where such harms are clearly outweighed by these other considerations which point in favour of a grant of permission that VSC will exist, such that permission should be granted. Third, sir, the VSC test does not entail a rigid mathematical totting up exercise, nor does each separate element of Greenbelt harm have attributed to it a separate batch of substantial weighting in the balance. And so I there set out a paragraph from the decision of Mr. Justice Eyre, QC, in Sefton Borough Council. And again, sir, I know you'll be familiar with that. Fourth, sir, entirely ordinary considerations can, when aggregated together, combine to produce the very special circumstances required to justify the grant of planning permission for inappropriate development. There, sir, I've given you the decision of Mr. Justice Sullivan in Basildon. So I note I've not given you the paragraph number. Paragraph is paragraph 17 of the decision. I just need to touch briefly on two matters in this context, which my learned friend raises. Firstly, sir, this, in terms of learned friend's paragraph 3, what she says is that, well, look, there's a big issue in terms of need, there's a big issue in terms of harm. There are, aside from that, minor differences between the parties as to the weighting attributable to other issues. That's all very much peripheral to the main issue. So that is not accepted by the appellant. These are not minor differences. They are material differences. And they are not very much peripheral. As Mr. Justice Sullivan says, all positive considerations must be weighed in the balance, and so they must be weighed appropriately because they contribute significantly to the very special circumstances case. So I come back to paragraph 48 of my learned friend's submissions, where she again seeks to essentially marginalise all other issues aside from need and to place this as a straight fight between need and greenbelt harm. So I note the final clause in her paragraph 48 reads as follows. In the council submission, the scheme succeeds or fails based on whether the apparent requirement to meet the data centre need on this site clearly outweighs the greenbelt and landscape harm. So, I mean, that is quite simply wrong in law. Were you, or indeed the Secretary of State, to adopt that approach, the decision would be unsound. The law is quite clear as to how matters should be processed for the purposes of this decision, and what my learned friend commends to you as a way forward is unlawful. So, sir, I come back then to my paragraph 26, where I say that the principles that I have outlined in paragraph 25 provide the clear framework within which this inquiry and the Secretary of State should determine whether or not to grant planning permission for the scheme. And so I say they represent the correct approach as stated by policy and as recognised by the courts. I come on then to development harm. It is acknowledged that the scheme will result in some degree of planning harm. However, such harm is, even on the council's case, limited in its scope and degree. Indeed, given that the proposed development would comprise of up to 84,000 square metres GEA or built development, the limited extent of harm that would result is notable. In this regard, there is much common ground as regards the discussions concerning harm, and in the following paragraphs, the appellant summarises this position. So I'm going to come to the harms in a moment, but I apologise, I need to make one brief segue here, and it is as regards paragraph 6 of my learned friend's closings. Paragraph 6, Roman 1, it's where she seeks to reheat the issue of power supply and in some way to present this as a matter which counts against the development. So you will recall that Mr. Collins gave uncontested evidence on this point. I chiefed him on it. He was not asked a single question in cross-examination. Thus, the local planning authority does not contest that the site and the development is provided with power. And so the proof is in the pudding there, because you'll recall also that learned friend's planning witness, Mr. Carpenter, makes not one reference to power supply in his proof of evidence, and in his planning balance, he makes no reduction as regards any alleged uncertainty of the provision of power supply. On then, sir, to paragraph 28 of my closings, where I deal briefly with heritage. So I say this topic can be considered briefly as it is essentially common ground. There is no discussion of heritage harm in either the council's reasons for refusal, its statement of case, its opening submissions, or its evidence. Indeed, the sole reference to heritage harm is contained in the planning balance table set out at paragraph 6, spot 51 of Mr. Carpenter's proof. So there he attributes limited weight to the harm that would be caused to the heritage significance of designated and non-designated heritage assets. Such weighting is consistent with the fact that the harm identified by both the appellant and the council is at the very, very lowest level of less than substantial harm. So the decision of the Court of Appeal in Palmer is authority for the proposition that the weighting of harm to heritage assets is not uniform and should reflect both the value of the asset and the degree of harm caused. So both parties agree that the public benefits clearly outweigh the harms for the purposes of NPPF para 208. On then, sir, to greenbelt harm. So the position as regards greenbelt harm similarly involves a degree of common ground and can in fact also be taken relatively briefly. In this regard, notably, both the appellant and the council agree the following matters. First, the scheme comprises inappropriate development in the greenbelt. As such, it will necessarily cause what is sometimes referred to as definitional harm. Second, the scheme will result in harm to the openness of the greenbelt, both visually and spatially, since it would introduce substantial built form onto the appeal site, which is currently open. Third, sir, the scheme would conflict with one of the purposes of including land within the greenbelt, namely that of protecting the countryside from encroachment. So not only are all these matters agreed, but it is agreed also that the harm they represent should attract substantial weight in the planning balance. So I do drop to the footnote here. In this context, we note that in his table at para 651, Mr. Carpenter attributes significant weight to this greenbelt harm. So there is no mystery here. It's simply a question of terminology. Mr. Carpenter confirmed in cross-examination in answer to a question regarding economic benefits that a weighting of significant is the top of the range weighting that he uses, i.e. it's akin to him using substantial. So I'm going to come back to that later on, but I do flag it there. So back to my para 31, it is on that basis that these submissions turn briefly to consider matters which are also relevant to consideration of the greenbelt, but where the parties are at odds. Other greenbelt purposes. Firstly, sir, there is the question of other greenbelt purposes with which the scheme is said by Mr. Carpenter to be in conflict. In this regard, the appellant notes at the outset that Mr. Carpenter initially sought to contend that development of the scheme would conflict with the purpose of preventing neighbouring towns from merging into one another. However, he ultimately withdrew this argument in cross-examination, noting the following matters. Firstly, the council officers did not cite any conflict with this greenbelt purpose. Secondly, reason for refusal 1 noted 2 conflicts with greenbelt purposes, which purposes did not include this one, such that his argument was stepping outside of the reason for refusal. Third, the statement of case, which he himself had drafted, did not cite conflict with this greenbelt purpose. Fourth, the council's own landscape sensitivity assessment addendum stated expressly that development of the appeal site will not contribute to coalescence settlements. Fifthly, neither of the council's greenbelt studies include Abbots Langley in its list of neighbouring towns at risk of coalescence. And lastly, Abbots Langley is not a town, but a village, as per the evidence of Councillor Edwards. Thus, that point in Mr. Carpenter's evidence can be disregarded. So the other greenbelt purpose on which Mr. Carpenter sought to rely was that of checking the unrestricted sprawl of large built-up areas. Here, sir, he was at odds with Mr. Hutchison, who noted the fact that whilst both the council's greenbelt studies contained lists of large built-up areas, neither of those lists include Abbots Langley. He also noted the fact that the M25 would serve to control development with a strong, prominent physical and visual boundary so that it could not properly be regarded as uncontrolled. Now, Mr. Carpenter's answer to these issues was to point to the output of the greenbelt studies, both of which recorded the relevant parcels as contributing to this purpose. That is, whether parcel 12 in core document E3A, which recorded a significant contribution, or parcel AL3 in CDE 4B, where the contribution to this purpose was relatively significant. However, sir, this is to ignore the fact that parcel 1, on which all built development would be located, comprises only a fraction of those parcels considered for the purposes of the Green Belt studies. And so I ask you in this context to note also Mullen & Friends paragraph 32. Just for your notes, it's the same issue there. What Mullen & Friend sought to do in her closings is the same thing that Mr. Carpenter sought to do, which is to elide parcel 1 of the appeal site with parcel N12 or parcel AL3. Quite simply, sir, these are different areas of land. Elision is wholly inappropriate. Returning to my text, sir, as such, the Green Belt studies So I say, as such, the Green Belt studies do not provide Mr. Carpenter with an answer. Still less do they provide an explanation as to how it is that development adjacent to a settlement, which is not a large built-up area, could contribute to urban sprawl from a large built-up area. I mean, it's essentially what Mr. Carpenter's approach does is seek to rewrite national policy so that it means what he would wish it to mean. The other point taken by Mr. Carpenter was that in the Woodlands appeal, the Secretary of State concluded that the appeal site in question on that occasion made a contribution to the Green Belt purpose regarding urban sprawl. Now, so there are short points in response here. One of those is that the factual matrix in the present case is different to that in the course of the Woodlands appeal. So I've given you the example in brackets there, so that the Green Belt studies here exclude the settlement from lists of large built-up areas. That is wholly in contradistinction to the position that Mr. Hutchison explained, that there, in the context of Woodlands, it was acknowledged that the appellant was dealing with a site located adjacent to a large built-up area. Secondly, another factual example could be said to be the motorway. Again, here we have a motorway in a prominent position on embankment. There, Mr. Hutchison explained in cross-examination that for a very large part of the relevant boundary, the M25 is in cutting, and indeed one could barely see the traffic from the appeal site. So the factual position was different. Also, sir, here the arguments are different in the present case to those which were put in the context of the Woodlands appeal. In Woodlands, it was accepted that there was conflict and that there was harm in terms of that Green Belt purpose. The only point of dispute was a question of degree. That is not the position before this inquiry, so that is not the argument which I make and the evidence which Mr. Hutchison has given in relation to this Green Belt purpose. On to paragraph 38, sir. Accordingly, whilst this is not by any means the largest point in this appeal, the fact remains that the appellant disputes the council's position that the scheme would conflict with the purposes of checking the unrestricted sprawl of large built-up areas. On then, sir, to Grey Belt. So here the point is a brief one to be picked up later. Discussion with Mr. Carpenter in cross-examination regarding the concept of Grey Belt land, as contained in the draft NPPF consultation, established that there is in fact only one single basis on which he resists the proposition that the appeal site would fall to be considered as Grey Belt land on the policy wording as currently drafted in the consultation. That is, Mr. Carpenter suggests that the appeal site would strongly perform against one of the Green Belt purposes. Now, here he is at odds with Mr. Hutchison, who considers that the appeal site does not make a significant contribution to any of the Green Belt purposes. In all other respects, Mr. Carpenter conceded that policy guidance, whether set out in paragraphs 152, 155, or the glossary of the draft NPPF, was satisfied. In particular, in this regard, Mr. Carpenter accepted expressly that the appeal site is a sustainable site, that there is a demonstrable need for the land to be released for development of national and regional importance, that development of the appeal site would not fundamentally undermine the function of the Green Belt in the district, and that the additional requirements of NPPF Para 155 can be met with regards to infrastructure contributions and provision of accessible open green space. Clearly, sir, this position is currently of limited relevance since the new guidance regarding grey belt is in draft. Further, it does not, indeed sir, cannot, serve to reduce the weight attaching to green belt harm, which weight must be substantial. However, given the potential status of the land as grey belt cannot directly bear in this context, i.e. that of harm, the appellant contends that it should be considered in the context of analysing those circumstances which may contribute towards establishing very special circumstances. I'll come back to those later. So the last consideration in respect of greenbelt matters is that of the future of the appeal site were the scheme to be refused planning permission. Clearly, sir, there can be no certainty about this issue as the notional future in this regard cannot be known. However, what are known are the following matters. Firstly, the council has currently identified housing allocations for its emerging plan, which would in no way be sufficient to meet its objectively assessed housing need, if assessed under the standard method. Indeed, Mr. Carpenter accepted in cross-examination that the existing allocations would need to be increased to the tune of 274% were the full need to be met. Secondly, what is also known is that the council previously, in the context of its Regulation 18 plan drafts, when it was seeking to meet some 90% of the then housing need, as opposed to the low growth figure of 42% of its housing needs, determined that Parcel 1 was suitable for housing. Further, and thirdly, what is also known is that the reason why the council did not pursue Parcel 1 as an allocation is because the site was withdrawn from promotion, not because the council regarded the site as in any way deficient for development purposes. In these circumstances, and given the direction of travel in terms of government housing policy, it is virtually inconceivable that in the absence of the scheme, the appeal site will not come forward for development in any event. So this, and this is the nub, this puts the council's green belt objections to the appeal scheme into clear perspective. And so I say that having regard to how Leonard Friend closed matters, which was essentially to say, no, the fact that this site may come forward for housing is a point which tells against the development. Now, sir, 2 points about that. Firstly, sir, it doesn't tell against the development. Rather, as I've just noted, what it does is to put into perspective the complaints which Learned Friend is making on behalf of the council about impact on the greenbelt, because this site, and in terms of its contribution to the greenbelt, she is essentially conceding has gone. The other point, sir, is this. Learned Friend closed and said that this point tells against the council in terms of, tells against the appellant in terms of the merits of the appeal. So that is a point that you will not find in the officer report. It is a point you will not find in a reason for refusal. It is a point you will not find in the statement of case. It is a point you will not find in any of the written evidence of any of Learned Friend's witnesses, in particular Mr. Carpenter. And sir, it is a point you will not find in your notes of the oral evidence given by Learned Friend's witnesses, in particular the evidence of Mr. Carpenter. That is a wholly new point introduced by my learned friend today. It has no evidential platform or heft whatsoever. Crucially, her planning witness does not agree with it, and indeed he accepted that this was a matter which should attract limited weight in favour of the appellant's position. So back to my proof at paragraph 44. Again, as with the grey belt issue, this fact, i.e. the future of the appeal site and what will come to pass, cannot serve to reduce the weight attaching to the green belt harm that would be caused by delivery of the scheme. However, it can, indeed must, sir, serve to be considered as a relevant material consideration in the context of the VSC test, as indeed Mr. Carpenter accepted fairly in cross-examination. Accordingly, sir, I return to that issue later in the context of the planning balance. So, sir, concluding remarks on the green belt. As such, at this stage, sir, the appellant notes only that the development proposed would result in harm to Greenbelt in the form of definitional harm, harm to openness in spatial terms, less so in visual terms, and harm to a single Greenbelt purpose. The appellant also acknowledges that substantial weight should attach to that Greenbelt harm. The only further point to make in this context is as regards precedent. Counsel for the council sought to make much, both in opening and in cross of Mr. Collins' answer, I note now in closing, of the fact that the appellant points to a need for further development of data centres in the Hemel Hempstead AZ beyond that now proposed. The scheme would, accordingly, it is said, serve as a precedent, with the Greenbelt effectively surrendered to whichever development proposal was promoted in whatever location, regardless of harm. All, sir, would be sacrificed on the altar of investment and growth. So that rhetoric, and we see it again, sir, in my learned friend's closing submissions, that rhetoric is unhelpful. It is also, sir, not sensible. Mr. Collins has identified a need for new data centre capacity, and that need exists. It is real. However, the only proposal before this inquiry is the scheme. Promoters of other proposals will have to find other sites if those proposals are to come forward. So indeed, planning authorities will need to identify those sites according to the draft provisions in the NPPF. Thus, data centres will not come forward anywhere, but presumably, sir, on other appropriate sites. In each instance, the merits of the position will no doubt be scrutinised by the council or, sir, by an inspector on appeal. And there is no question of abandoning the Greenbelt, and to present the promotion of this scheme as requiring some sort of Churchillian last stand, invoking the long and distinguished history of the Greenbelt, is to misrepresent matters dramatically. On then, sir, to landscape and visual impacts. So the final issue prayed in aid by the council in respect of harms caused by development is harm to local character. Here, notwithstanding the extensive evidence submitted on behalf of the council, the position in terms of harm is also constrained. In this regard, it is agreed that as regards parcel 1, there would be significant adverse impacts on the site itself and also in terms of local landscape character. It is also agreed that at year 1, certain visual receptors would experience significant adverse effects. Further, it is agreed that impacts would dissipate as one moved further from the appeal site. Beyond those matters, sir, the parties are indeed at odds. Mr. Harris was clear in chief that he regards both visual and landscape harm as being localised. The extensive existing vegetation, the local topography, and the fact that the development would be cut into the appeal site at 112 metres AOD all serve to limit the harm that would be caused. Further, Mr. Harris was also clear that the existing character of and visuals across the appeal site are such that the harm caused by development of parcel 1 would be limited. So in this regard, a notable point of dispute concerns the presence of existing highways infrastructure. Mr. Harris notes the presence of the M25 motorway, both the road itself, the lights, the gantries, the signage, and the traffic constantly moving along it, and takes the view that it is a prominent urbanising feature, especially combined with the presence of the Bedmond Road Bridge and the fact that, as Ms. Tinkler concedes, the appeal site itself comprises urban fringe. However, Ms. Tinkler seeks to argue that the M25 is not a dominant or prominent feature. Indeed, she suggests that noise from the road is barely audible. So with respect, the appellant contends that such approach is simply not credible. Not only does such view not square with the facts on the ground, it does not square with the assessment undertaken by the council's own consultants in the Landscape Sensitivity Assessment Addendum, which notes both the prominence of the M25 in this location and also the medium-low sensitivity of the landscape. Now, Ms. Tinkler rejects both of those propositions, notwithstanding they are findings which the council has commissioned and accepted. Indeed, sir, it is notable that Ms. Tinkler did not refer to core document H1, that is the sensitivity assessment addendum, in her proof of evidence or her evidence in chief at all. She did not even acknowledge it. Thus, sir, the appellant's position is that the council having accepted the limited degree of harm that development would cause at this location, i.e. Parcel 1, and having accepted the fact that development of Parcel 1 for significant residential development would be suitable, cannot now responsibly seek to contend that Parcel 1 comprises pristine green belt which should be preserved. On the contrary, sir, it is unremarkable agricultural land which does not benefit from any landscape or environmental designation, and which is not a valued landscape, which sits on the edge of built development, and which is enclosed within the angle junction of the M25 and other significant highways infrastructure, Bedman Bridge. It sits within the armpit, if you like. And so it is also enclosed by dense, mature vegetation along most of the boundaries and within the surrounding area. And so, of course, those are not my words, those are Miss Tinkler's own words. To the extent that Miss Tinkler sought to embrace other, less tangible considerations in the context of her Parcel 1 assessment, those matters do not find any support in the context of the Council's own analysis. By way of example, sir, her summary analysis of Parcel 1 includes the following. Other concerns relating to the proposed data centre include potential adverse effect on water quality resulting from construction works and the risk of polluted, contaminated materials entering watercourses and aquifers during operation, especially if battery energy storage systems are proposed. Also, the effects on recreational and residential sectors due to noise, lighting and disturbance, which during both construction and operation could potentially occur day and night. So there is simply no technical evidence to support any of these concerns on any level before the inquiry. No council officer or member takes any issue on any of these points. All such content in Ms. Tinkler's evidence amounts to speculation, and such speculation is all the more insidious because no warning of it was given prior to the submission of proofs. The points were not even flagged in the statement of case. So the only justifiable concern as regards impacts from Parcel 1 in landscape or visual terms related to the accuracy of the viewpoint 4 analysis in Appendix E to the LVIA. Now, so as Mr. Hutchison has confirmed, that imagery was deficient, such that the appellant had no alternative but to withdraw it. So I note in the footnote that we now have a replacement visual for you. So in the appellant's defence, it notes that whilst the mistake was not picked up by Mr. Harris in advance of the inquiry, so it was not picked up by Ms. Tinkler before she submitted her proof either. In any event, so the offending images have been withdrawn and replaced, and the appellant has confirmed and verified the remaining images. They remain robust. Thus, the sole tangible point in dispute as regards Parcel 1 is the question of planting. And Ms. Tinkler says it would not be as effective as the appellant suggests it will. Whips and feathers planted at year 1 will be no more than 5 to 6 metres tall by year 15 and will not serve to screen the development. So the answer here was clearly and definitively provided by Mr. Harris. The short point is that it will not only be whips and feathers that are planted. Instead, a range of different trees can be planted in combination with a range of different ages, and the precise detail can all be agreed at the reserved matter stage. Some of the specimens planted can, at year 1, already be as high as 8 metres. And so this more constructive and ambitious approach to landscaping will deliver precisely the type of benefits which Mr. Harris has identified can be secured at year 15, therefore, visual impacts will have softened and the development will cease to have significant adverse effects. On then, sir, to Parcel 2. This brings us to Parcel 2, sir, and here, as already noted, the Council advances no case in opposition. Rather, as Ms. Tinkler accepts, the scheme is regarded by members and officers as being beneficial. So that consideration in and of itself is sufficient to justify a limited treatment of it in closing. So the further reason these submissions treat the matter briefly is that in cross-examination, Ms. Tinkler herself also confirmed that as regards the various points she raised in her evidence, these could all, in fact, be addressed through the reserved matters application process. So she was not re-examined on that point. Now, sir, that is a matter that my learned friend did not refer to in closing. I do say, sir, that that is extremely surprising because, sir, the concession of Ms. Tinkler is, of course, incredibly significant. Half, indeed more than half, almost 60 pages of Ms. Tinkler's proof is concerned with the country park, that being an element of the development which she accepted did not form the basis of any reason for refusal. She accepted that all matters in those 60 pages of text could be solved through reserved matters. So in those circumstances, very, very little more need be said about it. All I do say, sir, is returning to the final sentence of paragraph 60, accordingly, it is common ground that insofar as Ms Tinkler does voice concerns, those matters can be suitably addressed and rendered acceptable through reserved matters. Having established that premise, there is little that need be said regarding the country park, and the appellant confines its commentary to the following matters. First, sir, the appellant does not anticipate the creation of an urban park in the manner of Leavesden Country Park. Rather, instead of built formal play equipment areas and sports pitches, there will be open grassland and meadow. Paths will be mown, and the only structures will comprise the occasional bench and or litter bin. So the facility will have a rural feel. Second, sir, whilst there is access to the area at present, this is confined to linear routes around the edge of parcel 2 or else crossing it in the manner of the Hertfordshire Way. So I do have to break here and ask you to note what my learned friend says at her paragraph 46. She speaks of a multitude of rights of way. So we are talking about 2 rights of way. That is to say, a right of way around the perimeter and a right of way that runs across. Multitude. So returning to my text, halfway through the second bullet para, the establishment of the country park will provide for full access throughout the 21 hectare facility, significantly enhancing public recreational access to this part of the Greenbelt. Third, sir, the proposals to provide an attenuation pond by way of a SUDS facility were well known.
Mr. Booth, apologies, my connection dropped for about 5 or 10 seconds there. I'm not sure if anyone else noticed it. If not, then it's likely to be my connection that's dropped rather than anyone else's. Would you be able just to go to the beginning of the sentence or go back? Because I'll have missed what you'll have said in the last 5 or 10 seconds. Apologies.
Okay, so I'll go back then. I departed from the text and then I returned to it to say that the establishment of the country park will provide for full access throughout the 21 hectare facility, significantly enhancing public recreational access to this part of the Greenbelt. Third, sir, the proposals to provide an attenuation pond by way of a SUDS facility were, sir, well known to officers, including landscape officers. Those proposals have not been the subject of detailed design as yet, but suitably qualified officers are content that they will be effective. And as Mr. Harris confirmed in chief, they will not need to sit in the precise location or form of the pond shown on the parameters plans. Rather, they can be designed to work with the contours of the landscape and will not need to have any significant landscape impact. Fourthly, sir, the proposed wetland scrapes, which the council's own ecologist confirms will help in part to deliver the agreed 140% BNG, whatever Ms Tinkler may contend, will be delivered in a way that works with the natural contouring of the land and will have no adverse landscape impact. So I mentioned that because in the Learned Friends paragraph 44, she's still talking about ponds on a hill and the fact that those ponds will need significant engineering works. So that's not what Mr. Harris was talking about. That's not what a wetland scrape is. So returning to the text at 62, all in all, the country park represents a substantive material benefit to the area. Any suggestion that it will result in landscape or visual harm is unevidenced, unsound, and indeed, sir, entirely contrary to the position of both the council and the appellant. Concluding remarks, sir, the overall position when taken in the round is that the scheme will mean a degree of landscape and visual harm to parcel 1, which land comprises an unremarkable section of urban fringe located adjacent to the M25, which on the council's own land assessment is of only medium-low sensitivity. So the harm will be localised and will reduce over time once planting matures to supplement the existing extensive boundary vegetation. In those circumstances, Mr. Hutchison's assessment, namely that moderate weight should be attached, is a balanced and reasonable one. Right, so it is at this point that these closing submissions now turn to address the other side of the balance. That is, so those considerations which the appellant praise in aid as contributing to VSC for the purposes of the VSC test. And so we begin with need. Perhaps the most fundamental consideration in the context of these appeal proceedings is that of need for data centres, in particular the national, regional and local need for new hyperscale data centres in connection with public cloud provision. So at one level, it appears that there is no longer much dispute as regards this issue. In particular, in this regard, Mr. Carpenter accepted that the national need is urgent and overwhelming. Such concession is in line with the view taken by the Inspector and the former Secretary of State when considering the Woodlands appeal. Further, Dr. Ford accepted, both in cross and in the needs statement of common ground, that not only is there a national need, but a regional need also. So I do underscore that point because paragraph 3 of Learned Friend submissions, she talks about conceding the national need, but makes no reference to regional need. So quite apart from the council having accepted all levels of need, even her own witness accepts the existence of regional need. So I come back to the final sentence in paragraph 67. So that is the council and both Dr. Ford and Mr. Carpenter accept that there is a need for further data centres to be provided in the London region. So I have paused there. In light of how matters have been put by Leonard Friend in closing, the references to Manchester, the references to other data centres elsewhere, be it on the banks of the Humber or indeed in Northumberland. So there is an agreed need in the London region. That London region need, for reasons I will come on to, must be met within the London region, and all discussion by my learned friend of Manchester, of the Humber, or indeed of Didcot and Cheshire, it is all so much smoke and mirrors, because there is a need in the London region, and quite what happens in Manchester is entirely beside the point. That need must be met in the London region. So I return at paragraph 68. Having acknowledged a national need and having acknowledged a regional need, it is at this point that the council pulls up the drawbridge. Whilst it accepts that the London region is comprised of a number of availability zones, and whilst it accepts also that the Hemel Hempstead AZ is just such an availability zone, it disputes the existence of any need within the Hemel Hempstead AZ. So it is for this reason that it is necessary to speak briefly to the respective witnesses called by the parties on this topic. For the appellant, sir, Mr. Collins provided what is respectfully submitted to be cogent and knowledgeable evidence regarding the need for data centres and the operation of the data centre sector more broadly. His experience is long-standing whilst also current, and for several years he has had day-to-day engagement with those bodies actively delivering data centres in the London region and beyond. He demonstrated complete familiarity with the various different types of data centre that are coming forward and the different roles and requirements of each. It was against that backdrop of that comprehensive understanding of data centre provision that he was able to speak to the particular needs of the Hemel Hempstead AZ and the need which the scheme would meet in that context. In contrast, the evidence for the council was given by Dr. Ford. Dr. Ford's expertise lies in renewable energy, not in the data centre sector. He once ran the business of an ISP which had its own data centre, but by his own acknowledgement, he has not been involved in data centres for, and these are his words, sir, around 20 years. To the extent that he ever had direct involvement with a data centre, such involvement ceased in 2008. He explained that since he was instructed by the council in late July 24, he has researched data centre related matters during these last 3 months and has clearly read a number of articles. So with all respect to Dr. Ford, he is simply not an expert with respect to data centres, and certainly there is no basis on which his judgment on such matters could reasonably be preferred to that of Mr. Collins. So this is certainly so as regards questions concerning the scale and quantification of need which is under discussion. That is, in terms of need, which the council accepts, if only at the regional level, the evidence before the inquiry as to the quantification of that need is all one way. Mr. Collins has quantified the degree of need by reference to market analysis and the assessment of the International Data Corporation. He has provided assessments for the London region and for the Hemel Hempstead AZ. He has provided an assessment which is grounded in evidence, which is conservative and which is robust. So this is in stark contrast to the position of Dr. Ford, who provides no assessment, no quantification and no analysis. Thus, while Dr. Ford seeks to contest the appellant's needs assessment, it is wholly unclear what he actually considers the need to be. Thus, the evidence of Mr. Collins should be adopted. So just to note briefly what my learned friend says on this point, at her paragraph 25, she refers there, sir, to the fact that she says no raw data is before you. Well, sir, I mean, that's wrong. As I say in the footnote, the core documents include the JLL assessment, the Knight Frank assessment, the CBRE assessment. I mean, so that's all before this inquiry. And then what my learned friend does at paragraph 26 is to fall into the self-same trap that Dr. Ford does in his evidence. Because you'll see at her paragraph 6, sir, she quotes from the Tech UK document, the report, and she cites it as saying, looking ahead in an industry characterized by disruptive technology is tricky. What we can say confidently is that it will change. So that is right. The Tech UK document says that, and indeed, sir, I believe everyone on this call would accept it. But, sir, in seeking to pick out that particular quotation, my learned friend has cherry-picked in precisely the way that Dr. Ford was shown to have cherry-picked when I took him through the Tech UK article, and well, all manner of positive analysis in that document had quite simply been ignored. For example, sir, I mean, that particular sentence, and you will go back to it in the context of the Tech UK document, which we looked at in some detail during the course of the inquiry, that document also talks about the fact that there will definitely be growth in the medium term. And indeed, I think it's the very next clause of or sentence that after that quotation of a learned friend, the Tech UK document says what we can be certain about is that there will be increased outsourcing to cloud. So it is wholly misrepresentative and indeed borderline irresponsible to suggest that the position before this inquiry is essentially, we don't know what's going to happen, no point in granting planning permission for any development in the Greenbelt because this could all be over by next Thursday. So, I mean, that is simply wrong. I return then to my text at paragraph 72. So I note in footnote 19, I've set out the actual statistical guts of the quantification of need that Mr. Collins provides. That's, I mean, you won't find any equivalent quantification in Dr. Ford's document. We come then to paragraph 72. The disparity in terms of expertise was also evident in terms of how the respective witnesses contend that the need can be met. And so we say this in this regard, it was telling that whilst Dr. Ford referred again and again to data centres located outside of the London region to demonstrate that the London region need could be met in places other than the Hemel Hempstead AZ, Mr. Collins provided a clear and concise explanation as to why those facilities did not serve Dr. Ford's purpose. In this regard, Dr. Ford, having stated that Immingham, Skelton, Eggborough and Camboys were all AI data centres, Mr. Collins explained that AI facilities, in contrast to a public cloud data centre, did not need to be located in an AZ. Indeed, Dr. Ford himself accepted that AI data centres did not need to be so located. Mr. Collins further explained that the facility at Didcot was intended to serve the life sciences cluster at Harwell and Oxford, and that the Google facility at Chesham would function as a private cloud facility serving confidential administrative purposes. So the only public cloud facility which Dr. Ford had identified at Saunderton was, he accepted, actually in an AZ in the Slough availability zone and so also in the Greenbelt. Thus, not one of the facilities identified by Dr. Ford served to help him establish the proposition that public cloud facilities serving the London region could be located outside of an AZ within that region. Further, sir, whilst Dr. Ford accepted that availability zones existed as an operational reality, that is to say, sir, both here and elsewhere, it's not the UK planning system. You find AZs in the US, you find them on the continent, in the flat D destinations. So, and whilst he also claimed to understand how AZ clusters operated and to understand the significance of ping or latency in this regard, it was Mr. Collins who was able to educate the inquiry as to how AZs operate and the imperative for proximity in order to deliver the sub-2 millisecond ping time necessary between data centers in order for them to function effectively as an AZ. So you'll recall, Dr. Ford was asked, did he know what the market required in terms of ping time and latency? And he said, no, he didn't. It's Mr. Collins that understands how the system works. It's Mr. Collins that is competent to provide that evidence to the inquiry. Returning to my text, 4 lines up from the bottom of para 73, Mr. Collins explained that ping is a limitation of physics. It is not a market invention as implied by Dr. Ford, and it is only where AZs function in this way that they provide the low latency and elasticity to enable efficient digital service that underpin the economy and market requirements. Mr. Collins further explained the need for the various AZs in the London region to grow, at least broadly, in tandem with one another, so that each is able to balance its respective share of the burden of the London region. It is for this reason that the provision of a further public cloud data centre in the Slough AZ, or, for example, the North Acton availability zone, will not serve to meet the need in the Hemel Hempstead availability zone. New sites will indeed need to be found in the Slough AZ, in the North Acton, in the Hayes, in the Docklands AZs, but that will not affect the need to also bring forward new data centre capacity in the Hemel Hempstead AZ. Now, sir, Dr. Ford's somewhat flippant suggestion, namely that since the London region has functioned relatively effectively with only limited contribution being made by the Hemel Hempstead AZ over the last 20 years, these are his words, sir, there is no reason that it won't be able to do so over the next 20 years. That's what he said in chief. So that betrays a complete lack of understanding of the rapidly increasing role of data transfer in modern society and the increasing reliance on the public cloud. The growth in demand is currently rising exponentially. And so to pretend that the position when Dr. Ford last had anything to do with the sector in 2008 will be anything like the position in 2038 is simply fanciful. This is an entirely new world operating with data capacity demands that are rising extremely urgently, and it is not open to the UK government to pretend otherwise. So it is for this reason that the need for data centres, as Mr. Carpenter accepts, is urgent and overwhelming. It is for this reason that Mr. Carpenter attributes the need for data centres significant weight. Now, in the course of his cross-examination, Mr. Carpenter indicated that such rating, i.e. significant, represented his highest gradation or level of assessment. Now, so if that is the terminology he adopts, then he is correct to adopt that highest rating. However, to be clear, the appellant does not consider such limited spectrum of terminology to be appropriate. Significant weight might be attributed to the provision of housing in a 50-dwelling development. Here, the position is demonstrably more acute. Mr. Hutchison says very substantial weight should attach, and we say, sir, he is not wrong. On then, sir, to the next issue, alternative sites. Before I come to the text, I'm afraid there are, again, one or two points I need to pick up on from the Learned Friend's assessment. One point the Learned Friend makes at paragraph 22. No, firstly, so paragraph 1 is this. At the foot of paragraph 1, she points to the fact that local planning authorities don't have the expertise that appellants or applicants do in this context. Therefore, she says they have to accept what is said to them about the need for data centres. Now, obviously, Three Rivers District Council have not accepted what's been said by this appellant. On the contrary, they sought to call evidence on the point. But that's in relation to need. She also says, sir, that, and I'm quoting what she says now at paragraph 1, they have to accept, local authorities have to accept without question what is said to them about the apparent lack of alternative, less harmful sites by developers. Now, sir, I mean, that is simply not right. That is a planning judgment capable of being made by any planning officer. The officers of this authority were in no way constrained to accept the ASA submitted by this applicant. However, they did accept it. The reason they did accept it is that it was robust. That's the first point I make about alternative sites and the ASA. The second point, I'll make it now, notwithstanding it's perhaps relevant a little later on, but because I've broken from the text, is this. In paragraph 22 of Learned Friend's closings, she seems to be suggesting that the alternative sites assessment should have a much, and this is the term, should have a much larger radius. And she does this having disputed the fact of Mr. Collins' evidence on ping times and effectively there being a 10 to 11 kilometre starting position, which one then withdraws within to 7.5 or 8 kilometres. So you will recall two matters. Firstly, at no point was there any question put to Mr. Collins to dispute his interpretation of the found digital report or the fact that the distance there cited was a there and back destination, there and back timing. He said, insofar as anyone goes to 20 kilometres, that's a there and back time, or a 19 kilometre, that's a there and back. What you're looking at is a 10 kilometres distance. It was never put to him. His evidence was not disputed. So, sir, first point is his evidence is uncontested, and therefore it is not open to my learned friend now to seek to introduce what is a wholly new point in closing. Secondly, sir, none of our own witnesses were competent to speak to that point. So I do say, sir, that insofar as it's now being said that there should have been a far larger radius for the ASA, that point is not one taken by council officers, not one taken by council members, and the evidence of my witnesses on this point was not contested. So I return then to the text at paragraph 77. Closely related to the question of need is the question of the lack of suitable alternative sites that can address the full need for data centres in this AZ without looking to the greenbelt. So in pointing to the imperative of meeting the full need, the appellant notes that the inquiry is not concerned with the possibility of locating the scheme on an alternative site. It is only if the entirety of the need can be addressed on a multiplicity of other sites that there would be an alternative to development of the scheme on the appeal site. That is what alternative means in this context. So this is another matter where, notwithstanding the position adopted by Dr. Ford, there does appear to be some degree of common ground in that Mr. Carpenter affords this consideration a positive, moderate weighting in his planning balance. Such weighting recognises necessarily a lack of alternative sites to meet the identified need. It is also consistent with the position adopted by the Council. I think officers in the officer report and members did not dispute the ASA undertaken by the appellant and accorded the lack of alternative available sites moderate weight in their analysis. That said, the evidence given by Dr. Ford regarding the ASA appears to contest the position as advanced by the appellant. Indeed, he goes so far as to say that it should not be relied upon. That is to say, the ASA should not be relied upon. So such position on the part of the Council's witness does not bear scrutiny for the following reasons. First, neither Dr. Ford nor the Council has identified a single site which he or it says should have been included and considered in the ASA. Now, in this regard, counsel for the Council says it is not the role for a local planning authority to identify alternative sites, and so that may be so in the first instance. However, in circumstances where an applicant or appellant undertakes an alternative sites assessment and the authority claims such assessment is deficient, it is incumbent on that authority to explain why and identify at least some, 1, 2 sites which it says ought to have been considered but have not been. And so we note that at the Woodlands appeal, of course, Buckinghamshire Council identified some 14 other sites which Mr. Hutchison was tasked with going to review. What the authority cannot do, sir, is to simply say, well, that assessment is wrong, and then put its fingers in its ears. La, 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 la. Second, sir, Dr. Ford's attempt to identify alternative locations or data centres which could meet the need of the Hemel Hempstead AZ and the London region have already been shown, sir, to be unsound by Mr. Collins, as I've already noted. Not one of his sites or facilities would meet the need identified. Third, sir, Mr. Collins explained why it is that the need for the Hemel Hempstead AZ must and can only be met in the Hemel Hempstead AZ. And so, in this regard, the Hemel Hempstead AZ serves a function as part of the London region. And for the architecture of the public cloud to effectively scale up, it can only do so within the established Hemel Hempstead AZ. Mr. Collins explained that data centres can only be added to the AZ if they are within the 2 milliseconds of ping or latency to the original data centre. So I've explained the parent-child concept in the footnote, so you clearly grasped that. Dr. Ford was having difficulty. I've set out the position there. So 2 milliseconds back and forth along fibre cables is the industry standard to provide instantaneous service for the cloud computing industry. Further, and as previously noted, each availability zone within the London region, including Hemel Hempstead, needs to expand broadly in proportion to the other AZs within the region so that they can each back the others up, provide redundancy, in the event of power failure at one zone or in the event of a peak in demand which overwhelms the capacity of one AZ and requires load balancing to another AZ within the region. Thus, the expansion of the Hemel Hempstead AZ is required for the Hemel market as well as the growth and resilience of the wider London region. So such analysis was accepted by the inspector in the Woodlands appeal, and the fact that the former Secretary of State in the previous government appears to have failed to understand the position does not alter, in Mr. Collins' words, the law of physics. So to expand briefly on this final point, and I appreciate we've covered this ground to some degree, but it is so important. Mr. Collins told the inquiry of the significance of the sub 2 millisecond ping requirement for those operators who would look to take forward a data center in the HHAZ. He explained ping in terms of the total round trip time between the sites for the origin of information to go from one data center to another and back again. And you'll recall, so he used his laptop cable. This mission-critical ping time creates a tight radius within which additional sites can be located to allow the expansion of the AZ. And if the sites are not within this time, the AZ is not able to function and services will experience lag. The fibre routes are critical to achieving this time, but these routes are influenced by geography and obstacles in the ground. Thus, the position broadly begins with a 10 to 11 kilometre radius from the parent site, but complications in terms of distance, obstructions, congestions would generally result in a shorter distance being drawn. It is on that basis that the 8 kilometre radius for the ASA was adopted, itself, sir, an extension of the 7.5 kilometre radius adopted for the alternatives assessment at Woodlands, and sir, which was accepted by the local planning authority, Buckinghamshire Council, in that appeal. So again, going very briefly to the text, the point which, well, I suppose we've made this point about paragraph 19 of Ellen Friend's closings and her saying that it's not a there and back distance. We've dealt with that. There just simply is no evidence to support her submission. So I can go then straight to paragraph 83. Mr. Hutchison spoke to the ASA and so he justified it as a sound analysis of the potential alternatives that were available for the purposes of the scheme. It serves to show that there was no alternative lying outside of the Greenbelt. So in terms of London Colney and the position taken by Dr. Ford in his note, I've set that out in some detail in the footnote of paragraph 24. Given Ellen Friend's reliance on that in closing, I have to address it now. So you'll recall that Mr. Collins indicated that there could be anomalies where a distance of 10 to 11 kilometres proved workable in terms of ping time. So this is relevant in the context of the discussion regarding the site at London Colney. The inquiry will recall that this is a site which has a flexible permission, i.e. it may come forward as a data centre. Mr. Collins was asked whether the Found Digital report identified London Colney premises as being within the AZ, and Mr. Collins, who was not the author of the report, indicated in cross-examination that the image was unclear and at a high level. As such, he wasn't sure. We know Mr. Hutchison has since confirmed that the site identified in the Found Digital image is not in fact London Colney, but a former garden centre. He further noted that London Colney is between 10 to 11k from the AZ and that it is not clear whether or not it is within the 2 millisecond ping time, so there's no evidence either way before the inquiry, and that it is not clear further whether it will be brought forward for B8 use or as a data centre. All we know is that no one's taken it on as yet. So thus London Colney may prove to be one of Mr. Collins' anomalies, or it may not. Certainly, and this is the bull point, sir, as Mr. Hutchison stated, it would not be appropriate to undertake an ASA by reference to a radius grounded in an anomaly distance, say 11 kilometres. Rather, it's appropriate to undertake one on the basis of an actual working radius. So back to paragraph 84. The only further matters to note in this context are the suggestions made by Dr. Ford regarding how, in his view, the ASA could have been improved. Now, in this regard, sir, none of the criticisms which he levelled hold water. His criticisms can be summarised as follows. First, he suggested that the ASA should have sought sites as small as 2.5 hectares and then sought to double up the height of the data centre to some 4 stories at up to 50 metres in height. However, sir, he identified no such small sites. Further, none of his identified data centres are located on sites of less than 10 hectares or run to such great heights. The reason for this is that building above 3 stories would cause significant operational and structural complications involving significantly and indeed perhaps prohibitively increased costs, owing to the weight of equipment, both cooling equipment and servers that are required. Dr. Ford admitted that he was aware of no operational reasons why one would not want to build to this height. Mr. Collins explained the position. The fact that Dr. Ford was not aware only speaks to his limited familiarity with the sector. Second, sir, Dr. Ford sought to suggest that the ASA should have countenanced a disaggregation of the scheme onto a series of small sites. So quite apart from having identified no such small sites, Dr. Ford ignores the issue that hyperscale data centres are promoted due to the massive savings, both in terms of cost and in terms of environmental impact, that they offer. And so to suggest that the scheme could be replaced by 4 different data centres is to disregard not only the market and its demand, but also the environmental benefits delivered by hyperscale. So it is no argument to suggest that a superstore be replaced by 4 corner shops. So in fairness, the council did eventually identify 1 site on the final day of the inquiry, that is to say the final sitting day of evidence, but as with so many other aspects of its case, so it failed to highlight the most important facts. These included that the planning application made in respect to the site in question was a speculative application without an operator on a 0.49 hectare site with a proposed development of only 2 stories in height, that would have a capacity of just 5 megawatts. That is 5% of the appeal scheme. So the fact that Millen & Friend didn't even reference, I think, this scheme in closing serves to indicate quite how irrelevant it is to the proceedings before you. Accordingly, sir, the ASA is robust and it is fit for purpose. You, sir, and the Secretary of State should accord the lack of alternative sites substantial weight in the same way that the inspector recommended the issue be weighted in the context of the Woodlands appeal. Again, sir, Mr. Hutchison's weighting is substantial. On then to economic benefits. So in terms of these, the position is clear, and this is because the council's witness, Dr. Ford, accepted without reservation the evidence provided by Mr. Stephen Nicol of Nicol Economics. Such acknowledgement was not to be found in Dr. Ford's proof of evidence, nor, sir, did he concede the point in the statement of common ground or in his evidence of chief. However, sir, when the matter was put to him in cross, he accepted the assessment of Mr. Nicol across the board. So in this regard, the headline figure is that the development of the scheme would comprise an investment of £1 billion. Mr. Nicol put that into context in his oral evidence, explaining that of the around 1,000 foreign investments made in the UK during the period 23 to 24, with which the Department of Business and Trade were involved, the average quantum of the economic impact of the investment was just 6 million. So in these circumstances, an investment of 1 billion is manifestly of huge importance, particularly given the sluggish state of the UK economy. Indeed, sir, only last week the Prime Minister was conducting a UK investment conference with the specific aim of attracting to the UK precisely this type of investment. However, sir, that is not the end of the matter. Mr. Nicol also explained in his evidence, and Dr. Ford also accepted, that delivery of the scheme would result in significant annual economic benefit to the Three Rivers and Hertfordshire economy of some £102 million, with economic benefits to wider London and South East economy of 230 to 300 million annually. Again, sir, these figures were accepted by Dr. Ford. Finally, sir, it is worth noting what all this means in practical terms. Whilst Dr. Ford was prepared to accept that delivery of data centres and infrastructure is essential to the digital economy, which in turn is fundamental to the UK economy, he refused to accept any link or connection between that and the myriad of individual commercial enterprises that together comprise the UK economy. And Mr. Nicol explained in evidence that was not questioned in cross-examination how it is that the thousands of individual businesses benefit from provision of digital infrastructure, and it is this infrastructure, including data centres, which enables economic growth, which represents the growth of the UK economy. The reality is that for all Dr. Ford sought to wriggle along this matter, Mr. Carpenter accepts, fairly and correctly, that these economic benefits are extremely significant. It is on that basis that he accepts that significant weight. Again, sir, his highest gradation of weighting, it's the same level he uses for harm to the Greenbelt. Significant weight should attach to the harm. Mr. Hutchison uses different terminology, but the upshot is that the parties agree that very great weight, Mr. Hutchison calls it very substantial, should attach to this benefit which the scheme would deliver. So an issue closely tied to that of economic benefits is the consequences that will follow were the appeal to be dismissed. Now, this is a matter which Dr. Ford dismisses entirely, and one to which Mr. Carpenter attributes only limited weight. So notably, Mr. Carpenter takes this view by reason of the fact that it is not this site in particular that is necessary to provide additional capacity. Thus, sir, and this is important, the position he takes is that this consideration attracts less weight because it is not a site-specific consideration. That, sir, is, of course, a flawed approach, as Mr. Carpenter himself conceded in the context of social benefits. In fact, and as Mr. Carpenter now acknowledges, the fact that a consideration is not site-specific does not justify it being disregarded. Further, the consequences of this development not coming forward are, on any reasonable view, extremely significant. The evidence of Mr. Nicol, Mr. Collins and Mr. Hutchison all combines in this context, such that the appellant notes the following by way of example. the prospect of a huge £1 billion investment would or could be lost to the UK. As Mr. says, there would be a real risk that instead of it being constructed in the UK at Abbots Langley, the hyperscale data centre would be constructed in another of the flat D destinations. So in this regard, it is important to understand that there are not infinite numbers of such investments floating around looking for homes. So this would be a particular investment which will go elsewhere if a suitable opportunity is not found in the UK. Next, sir, the UK currently punches well above its weight in terms of its digital infrastructure and the data centre provision. However, other European countries are keen to catch up and indeed overtake the UK. They are looking to take the UK's market share, and the refusal to consent this scheme would facilitate that. The UK, and in particular the new government, aspires to be a market leader in this sector, so that ambition will be dented, will be set back were permission refused. And so you'll recall the example given by Mr. Nicol was that of President Macron of France following the Brexit vote, seeking to take the commercial activity formerly grounded based in the City of London across the Channel to Paris. That's what we are talking about. Lastly, sir, in circumstances where data centre and digital infrastructure provision is inadequate and does not meet the needs of communities and businesses, then those communities and businesses will suffer and be at a disadvantage. As regards the latter, that is businesses, their growth and performance will be stunted by the lack of suitable infrastructure. Businesses will fail, or they will not invest, or indeed they will not even establish in the UK at all. Enterprises will go elsewhere and potentially locate on the continent. So the footnote there is pertinent because what Mr. Nicol did in the course of his evidence was reference the fact that the UK's economy as a services-based economy, not a manufacturing one, a services-based economy, is particularly vulnerable in this regard. It's particularly dependent on cloud and digital infrastructure. As to Paragraph 94, so these are all significant matters. They are all significant adverse consequences that would result from a decision to refuse the appeal. To the extent that Dr. Ford or Mr. Carpenter say, as they do, that there must be other locations available in the London region and beyond, which have not been explored and can meet this need. So I mean, they don't point to them, they just say they must be there. So that is wholly irresponsible. They do not proffer any solution or any means of addressing the need so as to avoid these dire consequences. They just seek to shunt the development off to somewhere, anywhere else. As Mr. Collins said, this is playing a catastrophic game of peekaboo. Buckinghamshire Council say go somewhere else. Now Three Rivers say the same, and all the while need is not met and the adverse consequences identified above will be snowballing. So what the inquiries at Abbots Langley and Woodlands have shown is that there is in fact a lack of alternative sites at not just one but two AZs. At some point, local planning authorities will need to take on the responsibility of facilitating this type of development rather than shutting the door in its face. So that is exactly what the draft NPPF proposes. Solutions need to be found if the UK is to achieve its aim of securing economic growth and being a global leader. So in these circumstances, Mr. Hutchison is entirely right to attribute this issue significant weight, and indeed it is cavalier for the Council's witnesses to give it only limited weighting. On to employment, sir. Here there does not appear to be material dispute. This is because, although Dr. Ford did not accept the position of Mr. Nicol, either in the form of evidence or in the statement of common ground, in the course of cross, he accepted it without reservation. To be clear, the construction of the scheme would provide some 2,500 temporary full-time employment jobs. Thereafter, in operational terms, the proposed data centre would provide some 210 full-time permanent positions directly, as well as supporting a further 400 to 1,300 permanent positions across London and the South East. So the wage bill for all this employment provision, the wage bills rather, are substantial. Witness the annual figure of 9.3 to 11.3 million for the permanent on-site positions alone. So that economic activity is without doubt yet another huge benefit of the scheme. In this context, the inquiry can note various suggestions made by counsel for the council in cross of Mr. Nicol. Notably, it was suggested to him that these were not high-skilled permanent positions, a proposition that Mr. Nicol firmly and robustly rejected, pointing to the highly skilled nature of the IT and engineering staff that would be required in order to ensure that the valuable facility operated effectively. Further, sir, it was suggested that staff would not work on site. Again, a notion which Mr. Nicol firmly and robustly dismissed. Lastly, it was suggested that it would be preferable for these jobs to be created in locations more needing of development, such as the Humber and the North East. Here again, and so this is the nub, Mr. Nicol painstakingly explained to the inquiry in Cross that it is not a question of electing to provide the facility and its jobs at the appeal site in preference to the North East. Rather, the North East simply was not an alternative. The appellant could not choose to provide jobs in the North East because any facility in that region and jobs created in that region would not serve to meet the need which the scheme is intended to address. And so again, I make that point in the footnote. I emphasize it because it seemed to be a key thread of Learned Friends evidence, Learned Friends submissions. Again, sir, in any event, the point ultimately seems to be one of rhetoric rather than substance, since Mr. Carpenter accepts fairly and rightly in his evidence that the provision of the full-time permanent jobs is a matter that should attract significant weight, as per the assessment of Mr. Hutchison, and that the provision of temporary roles in connection with construction should attract moderate weight, again, as per the assessment of Mr. Hutchison. So the next issue for consideration is that of social benefits. And here the appellant advocates that significant weight should attach owing to the innumerable ways in which the scheme would help to support the fabric of modern society. So in this regard, social communications, medical, legal, transport, media, and all too many other systems are grounded in the digital infrastructure on which society now so fundamentally depends, as Mr. Nicol eloquently explained. Thus, the scheme would deliver myriad social benefits. Now, the position of Dr. Ford, however, was to the effect that since those benefits are already available, nothing more will be secured by provision of the scheme. Such position is simply untenable. The demand for data-driven services is rising sharply, and if further infrastructure is not provided, then these services will not be available, or alternatively, they will be available only in a partial, rudimentary manner that will frustrate the proper functioning of society. Thus, Dr. Ford's position is essentially naive and impractical. Mr. Carpenter's position did indeed recognise the importance of these social benefits. However, his stance was, in his written evidence, that these benefits should nevertheless attract no weight, since the same benefits would be delivered by the scheme were it to come forward on another site in another location. Now, sir, Mr. Carpenter did not volunteer to revise that position in his evidence in chief, but he did concede it in cross-examination. And so you may think, luckily, it was that I asked him the point, or else we would never have known. But I did put the question to him, and he answered in cross that it is, in fact, no answer to say that benefits may be delivered on another site. Benefits are benefits, and the question of where they will be delivered does not affect their value. Indeed, sir, his position was untenable, given that he recognised the value of the employment benefits delivered by this scheme, even though those self-same employment benefits would have still been delivered were the data centre to be delivered on another site. As to weight, Mr. Carpenter sought to concede only moderate weight, so that in and of itself represents a marked departure from his original planning balance, nil weight, and serves to undermine his balance. However, it is not sufficient, and you, sir, and the Secretary of State are respectfully requested to agree the position of Mr. Hutchison. Significant weight. On then to the country park. Here the appellant, through Mr. Hutchison, notes that provision of the country park, together with more than 140% of BNG that it would deliver, should attract significant weight. So this is not an overstatement, given the fact that the country park would represent such a significant addition to local recreational opportunity. It's at 21 hectares. Certainly, it is more realistic and reasonable than the limited weighting afforded by Mr. Carpenter, whose view of the country park has evidently been tainted by the, I do say this, partisan hostility shown by Ms. Tinkler. His view is also at odds with the council, given that officers welcomed the facility and afforded it moderate positive weight. On then to the absence of a plan-led solution. At the outset of his evidence, Mr. Carpenter bemoaned the fact that the scheme was not being promoted through the local plan process. It was said that such development could only be properly planned for in that way. Now, so such approach is, in a sense, commendable. However, it ignores the fact that not only is there no allocation in the adopted local plan, but there is no draft allocation in the emerging plan either. Further, the submission of the Regulation 19 plan, which is not currently planned to contain any data centre allocation, is delayed, and there is no prospect of any plan being adopted before some point in 2026. Thus, there is no plan-led solution available. Now, as noted before, Mr. Carpenter offered nothing in his written assessment in respect to this issue. Following cross-examination, he accepted that it is a matter that should attract weight, notwithstanding he had attributed none. Thus, a further flaw in his assessment. He sought to suggest only limited weight, albeit he accepted that this should rise to moderate weight in the event that the proposed amendments to the NPPF are adopted. However, sir, once again, you, sir, and the Secretary of State are politely requested to adopt the approach of Mr. Hutchinson. Significant weight is the appropriate judgment. So I think this is my final reversion back to Learned Friends closings. The note here is as regards paragraph 29. The point I make is this. So what Learned Friend says to you is, well, look, this is all very new, and we, the local authority, should not be punished for the fact that there is currently no plan-led solution. So I do say that that is very, very strange language. Mr. Carpenter used it also. It is, if I may say so, incredibly self-indulgent on the part of the council. It is navel-gazing for the council to talk about itself as being punished. This is not a question of the council being in the wrong. No one is suggesting that the council should already have a plan in place which deals with these matters. It is not being punished. It is simply a question of dealing with the local, regional and national needs for data centre provision, and there being no data centre provision made in any planning document that comprises part of the development plan. No one is being punished. All that is happening is that you, sir, are being asked to have regard to a relevant consideration, which is that this area, part of which falls within the Hemel Hempstead AZ, makes no provision, and sir, provision needs to be made. Nobody is being punished, and it is wrong of the council to speak of itself in those terms. We're just seeking to provide the best location for development. On then, sir, to paragraph 108 and climate change. This point can be taken shortly. Mr. Collins explained how it is that hyperscale data centres provide a far more energy efficient treatment of data and thus are far more environmentally sustainable than smaller, older facilities. So such consideration is significant since it is not a choice as to whether or not the UK should have data centres. The UK must have these facilities as the government recognises. So fundamental are they to the functioning of society and the economy. So in these circumstances, it is a significant matter that data centre capacity be provided in the most environmentally sustainable way possible, that is hyperscale. And thus, Mr. Hutchinson is right to attribute the point significant weight. On then, sir, to the future for the appeal site. So a further relevant consideration is the point already touched on regarding the future of the appeal site, in particular parcel 1, in the event that the scheme is not permitted. In this regard, the fact that there is a strong prospect that the site will not remain open, agricultural land, were the appeal to be dismissed, rather that it would be brought forward for significant residential housing development, must bear on the question of VSC. Although it is not a matter he has regard to in his proof, Mr. Carpenter conceded that the likely future of the appeal site is a relevant matter to which you, sir, and the Secretary of State should have regard. Again, sir, this undermines the balance that he's undertaken in his evidence. So he contends that such is the uncertainty surrounding whether or not the site would be developed that only limited weight should attach to it. However, sir, having regard to the analysis set out earlier in these submissions, the appellant's case is that there is no real uncertainty. Development is almost inevitable. And in these circumstances, the fact that the appeal site would not remain open, even were the appeal to be dismissed, is a consideration to which significant weight should attach, as Mr. Hutchinson contends. Lastly, sir, grey belt. This consideration is one that can attract only limited weight at present, but it is one that should be noted all the same. Were draft policy to be adopted in its current form, it is the position of Mr. Hutchison that the appeal site would comprise grey belt land, and the scheme would not have to demonstrate VSC to justify a grant of permission. It has already been confirmed that the single premise on which Mr. Carpenter would rely in order to resist that proposition is his contention that the appeal site performs strongly against one of the Greenbelt purposes. So Mr. Hutchison firmly rejects that proposition. And so if you and the Secretary of State were to accept Mr. Hutchison's view over that of Mr. Carpenter, then the draft guidance would support grey belt approval without the existence of VSC. And so whilst by no means a determinative consideration, it should carry some limited weight in the context of the determination. Indeed, sir, it may end up carrying a whole lot more. Finally, sir, conclusions. The exercise to be undertaken by you yourself, sir, and the Secretary of State is to carry out the VSC test. That process involves weighing the material harm to green belt and landscape and very limited harm to heritage assets as against those considerations which point in favour of the grant of permission. Such considerations are numerous and powerful. In particular, matters of need, economic benefit, and the consequences of not permitting the scheme are particularly prominent. The appellant recognises that VSC will only exist in circumstances where the positive considerations clearly outweigh the harms identified. However, sir, the fact is, in the present case, those positive considerations do not just clearly outweigh the harms, they outweigh them so comprehensively that the effect is overwhelming. It is on this basis and on the basis of the matters addressed in these submissions that the appellant maintains its evidence has demonstrated that VSC manifestly exists in the present case. Accordingly, sir, the appellant submits that you should recommend and the Secretary of State should ultimately determine that planning permission should be granted. So unless I can assist you further with 4 minutes to go, those are my closing submissions.
Thank you, Mr. Booth. I think that concludes the inquiry for today. Closing the inquiry, I will keep the inquiry open until we've had the comments back on the condition. And then I'll formally close in writing. But in terms of the evidence given and the closing submissions, that's everything. I'd usually give an indication of timings at this point, but obviously I'm in the Secretary of State's hands. And so it'll be very much, once my recommendation is sent to her, then there'll then be a process by which she issues the decision in due course. Just before I close today's session, are there any applications for costs that need to be made by either side?
No, sir.
No, thank you, sir.
Okay. Thank you. Just wish to thank you for your attendance and for your contributions and cooperation. Thank you, Ms. Graham-Paul, and thank you, Mr. Booth.
Thank you very much, sir.
Thank you, sir.
Thank you. Goodbye.